Oyez, 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 all persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning.
Would the attorneys for the second case please turn up your video and mute your microphones? Thank you.
Mr. Hughes, you may proceed.
Thank you. Good morning, and may it please the court, Paul Hughes for petitioner Portillo Flores. This case concerns fundamental principles of administrative law. When adjudicating a case, the agency must apply the correct legal standard. It must supply sufficient, cogent reasons for its conclusions, and it must issue a decision demonstrating that it has discharged its duty to consider the relevant evidence. When an agency fails at any of these essential tasks, a court may not affirm by doing the work of the agency itself. Here, the agency failed at every turn. In assessing whether Portillo's abuse reached the level of persecution, the agency applied an erroneous legal standard. It held that repeated instances of violence qualify as persecution only if an individual requires medical care. The Third Circuit recently rejected this standard, and this court should as well. Other than that legal misstatement, the agency failed to provide any articulable reasons for arriving at its conclusions. As to government control, the agency again failed to apply the correct standard. It did not address whether Portillo's failure to request police assistance was justified because doing so was either futile or would put him at risk. And the record was filled with evidence satisfying the standard.
Counsel, on the issue you just raised about whether Mr. Portillo Flores's report would have put him at risk, was that issue addressed in the brief to the Board of Immigration Appeal?
Yes, Your Honor, the issue was preserved in both the notice of appeal and in the brief to the BIA. So can
you please point to the JA sites, please?
Yes, Your Honor. I'll start with the notice of appeal, which is at JA 47. And this court in Lizama said that the notice of appeal is the important place to begin for preservation to the BIA because the brief itself is in fact optional and is not required to be filed. And at JA 47, Mr. Portillo appealed the decision on past persecution. The issue here as to government control is a subcomponent of past persecution. We know that because in the ALJ's decision at pages 80 to 81, it was decided under the heading of past persecution. And of course, that's correct because the governing regulation at stake here, 8 CFR 1208.13b1, says that government control is a component of the past persecution analysis. But Your Honor, if we move forward to the BIA brief itself, which again is not required for preservation, but it was preserved there, the three different places in the record I would cite the court to are AR 18, AR 22, and AR 28. First, as to AR 18, Mr. Portillo gives very specific evidence that the police were complicit with him directly. That's at 18. At 22, Mr. Portillo makes the argument that, quote, the apparent utilization of local police to try to locate Portillo, along with other factors, clearly established that he suffered past persecution. And then at AR 28, he continued, this is about the CAT claim, but was making the same acquiescence argument in government control that's relevant to the CAT torture claim as it is to the asylum claim. And it again explained that the police inquired about him, were working in tandem with the local MS-13 clique. All of that, we think, more than adequately preserves this argument to the BIA. But even if we set that aside, we have our second argument, which alone is dispositive, and that is the BIA addressed the issue of a government control. And as virtually every court has held, when the BIA addresses an issue, even if it does so sua sponte, that is sufficient to preserve this court's jurisdiction in order to review that particular question. There was only one issue that the BIA found was waived, and there was no argument that Portillo made that he made a report to the police. Now, that issue wasn't advanced to the BIA because that's in fact correct. Mr. Portillo has never contested that point. He did not make a report to the police, but that's where the BIA erred in failing to apply the correct legal standard. It seems to have adopted a per se test that a failure to report is alone dispositive of the government control analysis. That's directly contrary to this court's law in the Ornelas case, where the court said that there's not a mechanical requirement to report if there is evidence that doing so would either be futile or would put the individual at risk. And here, there was very substantial evidence as to both points, but especially as to putting Mr. Portillo at risk had he...
But where did you raise this question of unwillingness and inability to control? I think it's important in a case where we're dealing with a private actor because the thrust of the asylum statute is to prohibit on a protected ground persecution by the state. And here we are dealing with a private actor, and I worry sometimes in these MS-13 cases that we are in danger of making MS-13 a de facto state. And so that's why the inability or unwillingness to control factor is a very important one. And will you just tell me and read me from the JA where you raise the issue of inability or unwillingness to control, not before the immigration judge, but before the BIA? Just read that to me where you raise the issue.
Your Honor, you would like me to focus just before the BIA and the BIA brief? Okay. Thank you, Your Honor. So as I said, it's in the Notice of Appeals, past persecution. This is contained within it. But beyond that, it is addressed in AR 18, AR 22, and AR 28. Those are the different record sites in which, to the BIA specifically, Mr. Portillo makes the argument that because police were collaborating with the gang, that demonstrated past persecution.
Well, why don't you read me the one that you think is most pertinent, where you actually brought that question before the BIA and satisfy the exhaustion?
Thank you, Your Honor. At AR 22, the bottom paragraph, Mr. Portillo said in his brief, the apparent utilization of local police to try to locate respondent. That is, with other things he's saying in that sentence, together viewed in the aggregate, clearly established respondent has suffered past persecution. That's at AR 22, where he specifically addresses the collaboration between, in his specific case, of the police and MS-13 leading to past persecution. Now, that's in addition to AR 18 in the second full paragraph, where he relays the underlying facts in that second paragraph that, quote, 4 policemen were working with gang members to come to respondent's mother's house, threatening respondent's mother so that respondent would turn himself into the gang. Respondent's mother saw El Pelon standing behind the police during that encounter, and she understood that El Pelon or the gang was linked to the police because they were asking about him. That's, again, one of the essential aspects of the factual accounting that was presented to the BIA, indicating an unwillingness or unableness of the police to report because it would have either been futile or because it would have risked additional danger. And then the last site that I pointed the court to is AR 28. Now, again, this is admittedly when he is discussing the Convention Against Torture claim, but there is the similar question to Your Honor's point about how do we ensure that MS-13 is just not equated with the government or made an action. I agree, Your Honor, with the court's concerns that there has to be a demonstration of government control, and it's certainly not a categorical rule that we would advance. And
Mr. Hughes, can I ask a question related to the second part of your argument with respect to this issue. If in fact you had not preserved this issue, and I'm not suggesting that you haven't, what should the BIA have done in its opinion? It seems to me that if in fact the issue had not been preserved, there would have been no cause for the BIA to conclude, as it did in the body of the opinion, that that finding by the immigration judge was not clearly erroneous. So it appears that the BIA engaged with the merits of the argument. And as you pointed out, there are a legion of cases where we and perhaps other circuits have held that where an agency, in this case the BIA, actually engages with the merits of the argument, that preservation or not, that's enough for us to be able to assess the merits of that conclusion.
Yes, Your Honor, that is certainly one of our independent arguments as to why there's no concern about preservation in this case, because irrespective of what the court may think about the notice of appeal in the BIA brief, the BIA squarely addressed the ALJ's conclusion, found it not clearly erroneous, and did not rest on any waiver point. The only point, again, as I said, that was squarely identified as waiver, where you would anticipate a waiver if the BIA believes there was one, was to the factual contention that there was no reporting. And that's because that point is uncontested and is not part of our claim here for past persecution.
Mr. Hughes? Mr. Hughes, Judge Keenan, I have a question, sir, about the fact that this child victim, how would you have us factor in child's age in determining the duty to report issue?
So Your Honor, I think the child's age factors directly to the duty to report issue, because as at least 5 circuits have held, in asylum claims, one must look at this via the lens of what you would anticipate as of a child. What would a child be understood to do in these circumstances? And as the court said, Ornelas, if there's a reasonable fear that reporting would lead an individual to be persecuted or reprisals, that is a reason to excuse a reporting requirement. In this context, we are not addressing the context of an adult filing a police report, but rather we must look at this through the lens of a 14, 15-year-old young teenage child to understand what was both subjectively and objectively reasonable for an individual from that vantage to undertake. And again, the evidence here was clear. Mr. Portillo testified that a friend of his had reported MS-13 to local police. They had been engaged in a racket where they were shaking down his friend's family business for protection money. His friend Omar made a report to police about the circumstance, and he shortly thereafter turned up dead inside a well. That is additional confirmation that an individual in these circumstances would have both a subjective and an objective reasonable concern about approaching police, especially when viewed through the lens of a young teenager. That was the analysis that the agency should have undertaken, but failed to accommodate both what the age of the child means as both the evidentiary burden and then the substantive standards that should be applicable. Now, I'll note the government does not disagree with us that the age of the child is relevant, and nor could it. DOJ's own guidance recognizes that, quote, the harm a child fears or has suffered may be relatively less than that of an adult and still qualify as persecution. That's the analysis that's been adopted by 5 other courts. And again, the government, I don't believe, takes issue on the face with that. And so the failure to engage there is independent legal error.
Mr. Hughes, on the bottom of page 80 of the JA, I think that's the very last 3 or 4 lines. The JA talks about the standard it applied with respect to government involvement. Is that an erroneous standard there?
The government, the standard was erroneous, Your Honor, because it did not continue to address what this court later said in Ornelas, that an inability or unwillingness can be shown of evidence of either futility or additional risk. And it's
I understand that. That's factual. That's the question of whether the standard was fulfilled by the facts. But the question is, that first sentence in the paragraph at the bottom of 80, is that the correct standard that should have been applied? Whether the government is unwilling or unable to control.
Your Honor, that statement is correct, but it's incomplete. It is a correct standard so far as it goes, but this court in Ornelas said that as a matter of law, there are additional ways to show unable or unwilling.
Well,
And that is,
clearly there are additional ways, but what I'm getting at is it looks to me that we're not talking about an erroneous standard. We're talking about an interpretation of the facts under that standard. And the immigration judge made findings based on various facts that he recited, and the BIA, as you pointed out, said that was not clearly erroneous. Now, if I'm correct that this is basically a disagreement with the facts, it seems to me the review standard by our court is one of the most constrained, most deferential in the law. I mean, we basically have to read that as conclusive.
but
I think I've lost people. Anyway, we have to read that as conclusive. That's the word the statute uses, unless compelled otherwise. And so if you agree that that's the standard, I'm wondering how we can get into that. I mean, there was evidence supporting the IJ's findings, and there was a conclusion by the BIA finding those not clearly erroneous. Now, that's the question isn't whether it was satisfied. The question is whether we were compelled to find otherwise based on those facts.
Your Honor, two principal responses to that. The first is there is a legal question that went unaddressed. That is, it goes to the futility or the risk that it would present, and that is the application of law to fact. But that requires a legal determination. I'll touch on that in a moment. But even if the court disagreed with that point, our second point prior to the application.
Well, that statement basically applies to every negligence case. I mean, you're basically saying that the insufficiency or the incorrect application of facts to the standard is a legal question. And I'm suggesting that the IJ announced the correct factual standard set by statute and then proceeded to make some findings. And whether those findings are what we would accept or not, it's clearly some evidence that the man did not go to the police. Now, that doesn't satisfy it necessarily, but certainly that can be considered as part of the standard because it then eliminates one aspect of the evidence that the police were never given an opportunity to respond. But my whole point is, it seems to me that you are converting a factual question into a legal one and to get around the statutory deference that we have to show.
Your Honor, as I said,
that's what I'm
Chief,
that's my biggest
Excuse me,
Chief,
sir.
I think we're missing Judge Wynn.
Yes, sir. Excuse me. I'm going to try to get him back in right now. Sorry about
Mr. Hughes, you may proceed.
yes, and Judge Niemeyer, as I said, really two principal responses that are both prior to application of substantial evidence. The first is the court in Ornelas refined the legal test. So the legal test is not simply unable or unwilling, but includes that as a matter of law, futility and danger to the individual will satisfy those standards, and that's part of the legal analysis that needs to be undertaken. But our second argument is, even apart from that, the record here fails to reflect that the court addressed fulsomely all of the pertinent evidence that was put before the court. And that's a question that is prior to the application of the substantial evidence.
Let me go back to your futility question. It seems to me if the court made the conclusion that, and properly can make the conclusion that it would be futile, the court would have to have evidence to support that. And the question in this case is the court clearly didn't think it was futile because there's no evidence to suggest it. There was a statement by a petitioner and some others that in the past there had not been a response, but likewise there was countering evidence introduced by the government. So the question of futility is also a question of fact, whether it was futile or not in the circumstances presented. My whole trouble is that there's a severe danger of us substituting our fact finding for that of the agency. And in this area of the law, there is a real separation of powers issue. We're told to keep our hands off of fact finding unless we're compelled to rule otherwise. Otherwise, we owe a lot of deference to the agency. And I think the record contains evidence on both sides of this issue.
Well, Your Honor, with respect, I think one of the key issues is whether reporting to the police would have triggered a danger to Mr. Portillo, which we know.
That's not the issue. The issue is whether the government was unable or unwilling.
Well,
that evidence you just recited was some evidence on which the immigration judge relied.
Well, respectfully,
but that is not the legal standard. That is a factual question.
Your Honor, I respectfully disagree with that because I think the court has defined the unable and unwilling analysis to include that if an individual would risk great danger as a subjective, reasonable, and objectively reasonable fear of danger for reporting is not required in that circumstance. And we don't know what the ALJ would have thought about that question if the ALJ addressed the record evidence.
Well, it may not be, but the point Judge Niemeyer raises, it seems to me, is a good one because in these MS-13 cases, we are getting very, very close to sort of taking judicial notice of the fact that MS-13 cannot be controlled and that as a general matter, the Salvadorian society and the country is in such a state of disarray that we are almost assuming that MS-13 is beyond control. And I think that's very dangerous for the reasons that Judge Niemeyer points out, and that is that it is drawing us away from the role that the immigration judge and the BIA is supposed to perform. And these are factual questions that relate to particular cases. But I share the concern that where MS-13 is involved, we are making an assumption as a matter of law that MS-13 is the one that's holding the reins in that society and that they've essentially overcome any efforts on the part of the El Salvador government to bring order. And I don't think we can approach it with that kind of broad brush. I think we have to look particularly at whether the particular persecution in the particular case was something that the government was unwilling or unable to control.
Thank you, Your Honor. And let me say, I think I largely agree with virtually everything you just said, because we are not asking for a per se rule in this case. that MS-13 is inherently outside government control. Our evidence that we asked the ALJ to address that went unaddressed was in addition to the general country conditions, because again, mind you, the government rests solely on general country conditions. We had very specific
Let me
evidence.
ask you on that point, isn't that what we're really talking about if we accept that futility is a question of law, but a question of fact, but the failure to consider it is a question of law?
Yes, Your Honor, the failure to consider both futility and the very real danger that this would present to Mr. Portillo, both of those are questions of law. And for example,
Mr.
the
Hughes,
evidence.
excuse me, I've been trying to get this in for like the last 6 minutes. If we could go back to Judge Keenan's question a while ago about the age of the petitioner here, how does that figure into all of this most recent analysis that you've been discussing with Judge Niemeyer and Judge Wilkinson?
Thank you, Your Honor. Even if we thought we were in substantial evidence territory, which for all the reasons we've discussed, we do not believe that we are, there had to have been a recognition by the agency that this has to be viewed via the lens of an individual who's 14 and 15. And that is a separate legal error because there was never an appreciation by the agency as to how you would view the questions of futility and dangerousness of risk to the individual via the appreciation of an individual who's 14 and 15. And again, that—
Well, you cited, when you were talking about this earlier with Judge Keenan, you cited other circuits. And have they done it in the context, considered age in this context that you're urging us to?
Your Honor, I believe the First Circuit in Ordano's Keno has recognized this because it is part of the past persecution analysis, both with respect to what conduct rises to the level of that we think is persecution, but additionally to the government acquiescence and the government control. Specifically, I'm not certain if a court has addressed it in the context of futility and dangerousness, but the analysis that those courts apply certainly holds here, because again, the past persecution analysis, understanding the dangerousness that an individual faced subjectively and objectively is part and parcel of the same question. Would an individual have a reasonable fear of going to authorities in their circumstances? That is basically two sides of the same coin. And so the application of that doctrine that all of the circuits have recognized in terms of whether past persecution or past events rise to the level of persecution would be fully applicable.
This raises the point that the whole argument began with, is what you raised and what was decided. And you're spending a lot of time now saying that as a matter of law, the immigration judge ruled that futility is not an aspect. But number one, I don't see that in your brief to the BIA. But I also note that the immigration judge addressed it. The immigration judge said the government of El Salvador has put measures into place to address criminal activity and has arrested gang members and corrupt police officers. Now, that to me is a response to futility as a matter of fact, not as a matter of law. I just don't see this being a legal error as you try to make it. We're talking about a disagreement with an immigration judge who was on the scene addressing these gang cases. And as you know, we get a lot of these gang cases, and there has to be some nuanced decision-making in deciding whether this is governmental action or whether it is simply criminal activity. And in this case, the IJ concluded that it would not have been futile because El Salvador is addressing the problem, has addressed it, has arrested gang members, and has arrested police officers. Now, the question is, where is the response otherwise? Well, the response otherwise is the one statement that he thought it would be futile to go because they hadn't responded successfully. But that sounds like a question of fact that was resolved and the BIA accepted.
Among the multiple legal errors we're talking about, I think the most clear in response to your question is there was no discussion or appreciation of the evidence that was very specific to Mr. Portillo. The quote Your Honor read, if that were sufficient, in the face of specific evidence of futility and danger, would be the sort of quote that an IJ could put as boilerplate in any case arising out of MS-13 in El Salvador in order to—
I want to ask you about that because I was intrigued by that too in terms of Judge Niemeyer's assertion. If that is true, that you can simply say you can make a general statement, they've arrested folks, they've been doing stuff, you would never have this instance then. You could always say it's not futile. Is that your point you're making? Because it seems to me clear there, there's nothing specific to this incident here. I mean, in every country, there's probably some incident of which when an issue like this is raised, there's something you can point in history, oh, they've done something. They did this, they did this. And if an IJ cites that, it seems to me from the perspective of Judge Niemeyer, then we're never futile. So it would seem this would never arise.
That's quite right, Your Honor, because the evidence that's cited there says that in a country with more than 4,000 murders, there was a handful of arrests, which does nothing to address the futility or the dangerousness point. But our fundamental point is the error here was not addressing the case-specific evidence about Mr. Portillo. He, from his own personal experience, had multiple incidents that show how there was a relationship between MS-13 and the police in his own individualized experience.
But Mr. Hughes, and I'm going back to this. I mean, nowhere in your brief do you talk about the fear he had because of the episode with his friend. Nowhere. And we've asked you for cites, and that just wasn't argued to the BIA. And it seems to me we got a threshold question of jurisdiction. But even if we don't, you're asking the BIA at least to address an issue that even with the benefit of a brief wasn't put before it.
Well, Your Honor, this is also against the backdrop where the government tells us that the court's task here is to review both the BIA and the ALJ decisions. Because the BIA summarily affirmed this is the government's own recounting, and I think they need it because they recognize the BIA decision is so defective. In the BIA's own accounting, what the task here is reviewing both the ALJ's action and the BIA's action together. And there was the ALJ was presented with very clear evidence about Omar, who turned up dead at the bottom of a well following his reporting to the police, and that went fully unaddressed by the ALJ. That is part of the decision of the agency that is before this court, and that was a fundamental legal error not to consider all of the evidence that was appropriately put before the agency decision maker in rendering a decision in the case.
Thank you, Mr. Hughes. For timekeeping, Mr. Hughes' reserve time was not noted. That's why I assume that he doesn't have any red light to reserve it. So in fairness to him, I suppose, over fairness maybe, we'll give him his 6 minutes that he reserved because we did stop the argument. But I please note that he didn't have his 6 minutes reserved. Thank you so much. Mr. McLaughlin. You may proceed.
Mr. McLaughlin, you're muted, sir.
You may proceed, Mr. McLaughlin.
My microphone says it is unmuted. Am I unmuted?
You are now.
Thank you very much. Good morning. May it please the court. My name is Andrew McLaughlin, and I represent the respondent Attorney General of the United States in this case. I will initially focus, unless the court guards me otherwise, on the argument that formed the basis of the petition for a hearing. But I want to take a step back a little bit further than the court has gone so far in reviewing the context of the arguments in this case. In his testimony to the immigration judge, the questions that Mr. Hughes has raised, the questions that were raised about why Mr. Portillo Flores did not report, were put to him in his testimony. And in response to those questions, twice, Mr. Hughes simply conceded. He said, I agree. I don't really know. The police might have been able to protect me, both within the context of the question of his friend who showed up at a well. All we knew there was that the reason that the friend this even came up was that the friend had reported a crime against him, extortion against him, and the police had in fact been able and willing to act in that case. And at some point later, the friend is dead. That's all we know. Mr. Portillo Flores was confronted with the fact that he didn't know that the friend was murdered. He didn't know who did it. He didn't know why it was done. None of those things are in this record. None of that evidence was presented. So Mr. Portillo Flores conceded. He said, yes, the police can protect me. Once again, later on in the argument, he was confronted with this question about the police coming to his mother's house, which, by the way, took place after Mr. Portillo Flores was already gone, after he had failed to report, so it's frankly irrelevant to begin with. But when confronted with the fact that the police came to his house, Mr. Portillo Flores again said, look, I don't know. The police might be able to protect me. So that's the context. That was immediately followed by an oral closing argument made by his counsel in which Mr. Portillo Flores didn't make any of those arguments. He simply said the police were unable to protect me because they came to my house. And that shows that they were involved. Yes.
Mr. McLaughlin, Judge Motz. I think that you make a fair point, and a point that was made in the majority opinion, but I don't see the equivocation of the petitioner here about whether or not he was able to go to the police being the grounds for the agency decision. Can you point me to a place where it is?
Your Honor, the question of futility or harm from reporting was not raised by petitioner's counsel to the immigration judge. And the immigration judge, if you look at that, responded directly to the points that petitioner's counsel made, directly to those points. Futility wasn't raised, and harm from reporting wasn't raised to the immigration judge by counsel, so the immigration judge didn't specifically respond to it. I would frame this in the way of an affirmative defense. If the defendant in a criminal case doesn't raise an affirmative defense, the judge doesn't address it. And if the evidence in the record doesn't support the affirmative defense, the judge doesn't address it. And both of those are present in this case. It wasn't raised to him, and the evidence specifically said, yes, the police can protect me. Therefore, the immigration judge didn't address it.
Well, Mr. McLaughlin, you know the record better than I do. So I think you'd have to admit that the record is mixed on that. There are the two statements you're talking about, but there are other statements in which the defendant does say that the police wouldn't have protected him. So, you know, I take the point, but I don't know. I think the fact of not resolving that or even relying on it by the agency seems a little odd.
No, I would say, given that the argument wasn't made to the immigration judge, nor was the argument made before to the board, Mr. Portillo Flores argues that simply having raised the question of past persecution somehow implicitly raises both the unable, unwilling issue and the subordinate question of whether there's an exception to the unable and unwilling requirement for futility, neither of which was mentioned. Neither of those things was mentioned to the board. So you can't say.
Why isn't it, Mr. McLaughlin, this Judge King, why isn't it important that the IJ believed the petitioner and believed his sister in their testimony?
Your Honor, Mr. Portillo Flores and his sister both expressed a belief. When questioned about the underlying facts that support that belief, the only factual information that was presented was conceded by Mr. Portillo Flores. He directly conceded the facts upon which his belief was based. He contradicted, he conceded. There was no basis for the immigration judge or the board to address it. Clearly,
Well,
and the board was looking for clear error.
Finds the guy's credible, which he did, and finds his sister's credible, which he did, and the bulk of his testimony goes against these two admissions, then doesn't he have if he's going to say he's credible, doesn't he have to have an opportunity or an obligation really to explain why even so he's credible?
No, Your Honor. The immigration judge isn't required to address every conceivable fact that takes place in the record. When Mr. Portillo Flores conceded it and his attorney failed to argue it, there was no reason for the immigration judge to waste precious time in his oral decision, which by the way, immediately followed that closing argument, in addressing something that counsel hadn't put forward. It just wasn't there. The issue wasn't presented.
Well, I
also,
think
Judge Keenan raised a point earlier about what bearing the fact that a petitioner is a minor or a juvenile would have. And I think the thing we're all concerned about is this question of unwillingness and inability to control. Now, being a juvenile, that wouldn't be related in some way analytically to this basic question of unwillingness or inability to control, would it? I mean, there's no showing that the security forces in El Salvador are somehow less willing to control persecution against children or anything like that, is there? I mean, these are unrelated matters, aren't they?
In that sense, I would certainly say they are unrelated, Your Honor. The question of the impact on a child runs throughout asylum litigation. And the board has never held that the impact of the child shouldn't be considered. And in fact, you can see from the board's decision in this case that it was considered. They first addressed past persecution and agreed that the immigration judge's past persecution finding was correct, that severe harm had not been shown, the kind of severe harm that this court requires and that the board requires for persecution. Then on the very next page, they go on and say, look, even if you assume that you can establish past persecution using this child mechanism, which we just got done telling you he didn't establish from our point of view, that's now changed because he's no longer a child, because the presumption that arises from past persecution is dependent on it being the same persecution as existed before. Now that he's no longer a child, the circumstances have changed, and he would not get, even if he did get the presumption arising from past persecution, he would not get it now because the persecution that's being alleged has changed. Before it was based on being a child, and now he can't make that argument about the well-founded fear being based on his being a child. So you can tell from the reading that
he was threatened with death. He was
no, Your Honor, he was not.
When he was 14 years old, and that was never withdrawn or changed.
No, Your Honor, he was not threatened with, he did not receive the death threats until he was 18, according to his own testimony. The only death threats that were made...
His sister testified to it.
Yes, Your Honor, and he testified that she did not tell him about those death threats until...
But we know when she got it. We know when she got the death threat, correct?
Yes, Your Honor, that's correct.
And that would be the controlling point.
No, Your Honor. The question with past persecution is the impact on the child. Mr. Portillo Flores didn't receive that threat, wasn't even aware of that threat based on his own testimony until he was 18 years old.
How about the actual beating to the point that he thought he might die when he was 14? Does it have to be a verbal threat? He actually received a physical threat of death. On several occasions.
He received verbal threats of some sort. He doesn't identify what sort of threats he personally received. And in fact, he thought he
was going to die.
Correct.
When he was 14 and beaten up.
That's correct. On one occasion, he thought he was going, he doesn't actually say it was a result of the beating. He said at some point during that event, he felt he was going to die. But so you have...
What do you think it would have been the result of?
Well, fear? I think when he was approaching the gang, he thought he was going to, they would hurt him. It doesn't, you can't really tell. The question here is, however, what harm did he receive? Threats themselves are only persecution if harm results. And so you have to have evidence of harm.
He was physically harmed.
Not by the threats, or at least that's not what's alleged here. There is no evidence from harm from the threats.
This makes no sense.
Mr. McLaughlin, can you reconcile your position with our cases of Bedoya and our recent case of Arita Darris? You seem to be saying it has to be a physical harm inflicted, that the death threat is not sufficient. And that's our jurisdiction. I mean, it can be death threat plus harm, but where have we said that there has to be more than a death threat?
Your Honor, this is why the government's brief describes why it's so important that this court clarify or correct its precedents regarding death threats. This court is simply wrong in concluding that a death threat in the abstract is past persecution. It's not.
It is wrong. Arita Darris is wrong. What else is wrong?
All the way back to Crespin Valladares, which is the first time that this court imported that phrase to say that death threats are categorically past persecution. If you look at where the phrase came from, it came from a phrase in the Refugee Convention and the statute that said life or freedom would be threatened. And in that context, it's not talking about words. It's talking about menace. The French word that's used in the parallel version of the convention is menace. So if I come at you with a knife, I'm menacing you. If I say I'm going to go get a knife and I might hurt you with it, that's a threat, and that's not what they're talking about here. So this court needs to reevaluate where its death threat case law came from and jettison it. As frankly, Mr. Portillo-Flores.
So you're admitting that for you to prevail, we need to change our precedent on death threats?
No, Your Honor, because the death threat wasn't made to Mr. Portillo-Flores while he was a juvenile and while he was in, it wasn't even made while he was in, it wasn't conveyed to him while he was in El Salvador. The
So
death
you're
threat
saying
was
conveyed wasn't enough, and then they sent him to the United States. That wasn't enough. The sister knew that he was being threatened with death.
That's correct. Mr. Portillo-Flores, in all of the decision-making that was made in El Salvador, in all of the harm that he endured while he was in El Salvador, was not aware, according to his own testimony, that his sister had been told that somebody would come after him. That he wasn't told that. His testimony says, I didn't know that until my sister submitted her affidavit as part of my asylum claim, and her affidavit is dated 2018. So Mr. Portillo-Flores wasn't aware.
It was credited and believed by the IJ.
His testimony that he did not know about the death threat. Her testimony was credited by the IJ.
That he was threatened with death that he was threatened through her with death when he was 14 years old, and as a result, they sent him to the United States.
And she testified that she never told him. He was not persecuted because he never knew.
So let me understand that point. You are essentially saying that a threat can in fact exist, but if he doesn't know about it, and the BI and the agency can find a threat actually was there of death, but because he didn't know it, he doesn't get the benefit of it.
He did not suffer past persecution in El Salvador, period.
I just want to be clear on that point. In other words, because he didn't know it, that in fact, he is being threatened with death. We accept that. He just didn't know it. And as a result of that, he doesn't get benefit. But let me ask you something on that point, because I think it's important, and I'm trying to parse out what's the difference here in terms of the opinion of the court that seems to be coming out. And that is, it seems that, well, it is true that the IJ doesn't have to address every fact, but our law does say that the agency cannot arbitrarily ignore unrebutted facts here. And one of the things I don't think the IJ decision didn't mention at all the testimony of the petitioner about the 4 policemen coming to his house, and I didn't mention Omar's death and his sister's testimony that the people in the neighborhood had a shared understanding that the police were ineffective. And then there's the detailed expert declaration on the Salvadorian police's inability to protect. Is it your position that the agency did not need to address any of this?
In this case, Your Honor, it is the position of the United States that the agency did not need to address those things. The agency didn't need to address those things.
You accept that the sister did make a declaration stating that the gang had directly threatened him with death. And from your point of view, that doesn't matter here because he didn't know it?
He was not persecuted in El Salvador on that basis. So with respect to past persecution, it is not relevant. However, it is relevant to whether or not he should fear, whether he would have a well-founded fear of future persecution.
And lastly, regarding Judge Thacker's question, she sort of went there. Apart from the threat, are you saying that the beatings alone would not be persecution?
That is correct, Your Honor. That was the conclusion of the board, that the evidence that was presented that contained no evidence about the severity of the beatings other than the fact that there were bruises from the last of those beatings, no evidence at all about the severity of the other beatings, but with respect to the last of the beatings, there were bruises such that the mother noticed them, and he felt he would die. That's it. That's all the evidence that there was. This court has had numerous cases where the severity of beatings was far greater than that. The evidence of the severity was far greater than that, and haven't reached any conclusion on that basis. The fact is, the evidence.
Counsel, it's Judge Harris. It looked to me as though the IJ and the BIA didn't say what you just said. They just said he didn't receive medical care, period. And I think the IJ goes on to say, and based on that, it didn't rise to the level of persecution. It could not be clearer that that's the only factor. So is there a case that says somewhere that if you don't receive medical attention, that's all we have to look at?
No, Your Honor. There is no such
okay,
there isn't a case that says
well,
that.
then didn't the agency apply the wrong legal standard?
No, Your Honor. The question here is
why not? That's all the agency looked at. That's literally all the agency looked at. So why, and you just said that's not the standard, so.
The question here is, did the harm rise to the level of persecution? And the question here is,
I guess I'm asking a different question. I'm asking a different question. Did the agency apply the right legal standard in considering that question?
The question of the legal standard regarding whether or not medical care is required wasn't what the agency addressed. The agency addressed whether or not the harm rose to the level of persecution. Was it severe?
Counsel, I'm just going to try. I will only try one more time, and then I will let this go. The agency said it did not rise to the level of persecution, and the one reason that that is so is because he did not receive medical attention. I am asking you, was that the right legal standard?
That was not the standard that the agency applied. It is not the right legal standard.
But the IJ said he didn't receive medical care, and based on that,
which is, by the way, a correct
the
statement.
level of harm.
Among the many pieces of evidence that shows that Mr. Portillo Flores did not establish.
The IJ said the injuries did not require medical attention, and based on that, the court finds that the level of harm that he experienced did not rise to the level of persecution. Was that correct?
If your conclusion is that was the sole basis for the immigration judge's decision.
How else am I supposed to read that? The IJ said based on that. Why are we doing this?
Your Honor, the question is whether Mr. Portillo Flores established severe harm. There is nothing in that that establishes severe harm. The question is what else would have established severe harm? The fact that he didn't seek medical care establishes. The fact that he characterizes it only as bruises characterizes. The fact that he could leave within a week to go to a different location in the country also establishes that this harm wasn't severe. There's numerous parts of the record that show you that Mr. Portillo Flores did not establish severe harm. The fact that the immigration judge points to, and frankly, mischaracterizes what was said, it characterizes it as didn't need it as opposed to didn't seek it, that doesn't mean that Mr. Portillo Flores met the legal standard, which was to establish that the harm that he experienced was severe. There is zero evidence of severe harm in this record, not a single bit.
So being beaten to the point that he thought he was going to die is not severe. Is that the government's position?
What an individual thinks is subject to being tested on examination. So being tested on examination,
well, he was found credible.
What his injuries were. Yes, what he did think it. That doesn't mean it's true. So it was tested on cross-examination. It was tested by the immigration judge. Frankly, it was tested by his own counsel.
Even for a 14-year-old?
well, at the time he was testifying, he was 18, but yes.
I don't see how that matters.
The short answer is there has to be evidence. There has to be evidence of something. What is the evidence of severity? There was no evidence of severity.
And did the BIA go through all of what you're saying, or did the BIA only address what Judge Harris read?
The BIA didn't say any of that. The BIA said the immigration judge did not clearly err they may have actually said something about the.
Oh, and you said but the BIA decision here was only a single judge, not a panel, correct? So how does that impact our review?
The fact that it was a single member, it is still the decision of the agency. It is it combined with the immigration judge's decision that they found was not clearly erroneous. Now, allow me to point out this question.
The single judge doesn't get as much weight as the panel. It's a different standard. Right?
They both receive deference. They are both the agency that has
not as much deference. Not as much deference. The single judge doesn't get as much deference.
That's correct. And this is the presence.
And the board claims to get the Chevron deference. It's different. This is a single judge that was trying to clean up the IJ for you. And he doesn't get as much deference as if he had the board with him.
That's correct. Let me point out, I misspoke earlier. The board specifically did say that medical care was not required. The medical care was not required as opposed to not receiving medical care. So the board examined what the immigration judge and concluded that he did not err in determining that the harm that it hadn't been demonstrated to be sufficiently severe based on not requiring medical attention.
I wanted to ask the question, follow up on Judge Harris, because I was trying to follow that logic. And she gave the reason that the IJ actually gave, and then you responded by giving various reasons why the harm wasn't severe enough, but the agency didn't actually provide it what you responded with. I mean, it seems we'll limit to what it actually gave, which is what Judge Harris dealt with, and then you responded saying, well, it wasn't severe enough, but that's not what the agency gave as provided as a reason.
Let me take a moment to ask you to look at Elias Zacharias and Bowman Transportation. In Bowman Transportation, the Supreme Court specifically noted that the agency didn't discuss certain evidence. And they said that's not a problem.
I don't want to get into a discussion of, I'm dealing with the facts of this case, and whether there are cases that would allow them to deal with it, we can wrestle with that. But I want to be clear, that's your point. And your point is that even though the IJ actually gave what Judge Harris read, there are other various reasons of harm that to indicate why it wasn't severe, but the agency didn't actually provide it. And your point is that based upon that, we should uphold the agency. And I don't quite follow that.
Your Honor,
now understanding you're saying there are cases that may say you can do it, but I guess that's what you're saying. But we can figure that out. But I want to be clear, that is your point here.
No, Your Honor. My point is the immigration judge's actual finding and the board's actual finding is there is no evidence that this harm was sufficiently severe to amount to past persecution. The immigration judge gave a specific.
Excuse me, Mr. McLaughlin. It seems to me that you're trying to argue around the point that Judge Harris was making, and you're really not helping us decide this case if you continue to do so. The IJ said, however, these injuries did not require any medical attention, and based on that, the court finds the level of harm that the respondent experienced did not rise to the level of persecution. The IJ narrowed the inquiry and based it on the absence of seeking medical care. And now you're searching through the record and asking us to be diverted from the fact that there's plain legal error here. How do you address the fact that there is plain legal error in the IJ's analysis?
Honestly, I think the IJ misspoke. But
just a second. Let me just refine that question, because I think the question blurs the fact that when someone doesn't seek medical care, may not describe the severity of the injury. But when the board, the IJ said it was an injury that did not require medical care, that does go to the severity. So that regardless, somebody who didn't require medical care could have still have sought it, and it still wouldn't make it severe, and vice versa. If it was not severe at all, the conclusion that it did not require, the level of the injury didn't require medical care, is different from whether he sought it. And in this case, the IJ addressed the level of the injury, which I think is directly supported by the evidence that only bruises were manifest when observed by the mother.
the question is whether you can discern what the immigration judge was attempting to say and what the agency was attempting to do. That's what the case law says.
But my point,
and here,
my point on this is not whether the person sought medical care. The point is whether the injury necessitated medical care. And it's the latter that the IJ addressed.
So, counsel, taking Judge Niemeyer's help for you, is it your position then, the position of the United States, that if someone does not seek medical care, that is a reason for denying them a benefit?
That is evidence that the severity of the harm was not great. No, I would say absolutely not.
I frankly think that laymen may often not know whether they need medical care or not. I've been with people that have had a stroke and did not think they needed medical care. So I'm not sure that I follow that. So maybe you explain that for me. Looking at what the agency said its reason was for denying relief here.
Your Honor, when harm is severe enough to amount to past persecution, you'll know. You know that the harm is severe. You know that you need medical care. You know that you should get medical care.
That is just that's not real world. I've literally been within the last 2 years with someone who had a stroke. You need medical care then. And they didn't know.
And that person wasn't beaten, Your Honor. When a person is beaten and needs
that's
medical
the
care.
little gloss you're putting on, what you said to me to begin with. If you need medical care, you will go get medical care. You'll know you need medical care. What I'm saying to you, that's not necessarily so.
And again, we're talking about a 14-year-old.
Correct.
Mr. McLaughlin,
without a medical degree.
Why don't you address, instead of whether somebody seeks medical care, it seems to me that would be an erroneous standard. But in this case, the IJ assessed the injury. In other words, taking Judge Mott's situation, if the person had a stroke, that injury required medical care, whether they knew it or not. In this case, the IJ assessed the injury and said the injury didn't require medical care, not whether he sought it or not, which is irrelevant.
I think you're absolutely correct. I would caveat that by saying,
tell us in assessing the injury, what was the evidence that he assessed the injury? Because all I see is the testimony of the petitioner saying he didn't receive medical care. And based upon him saying that, they said it's not required. I don't know of any evidence in this record that says they assessed an injury.
Your Honor,
if they did, they made it up.
The burden is on the applicant to demonstrate.
I understand that, but I'm simply going. I understand that. I'm simply going to the question as posed by Judge Niemeyer that they assessed the injury, and I'm saying the only testimony I see is that the petitioner saying he did not receive medical care, and based upon that, they then took it to the next step and says it was not required. But there's nothing underlying that says anything about assessing an injury. And to the point that's being made is that one can be in a position where, yes, you need medical care, but you didn't receive it. Or you may well have required it and you didn't receive it. But only thing you have here is the testimony of the petitioner that says he did not receive medical care. Now, had the IJ made that statement, perhaps we would be going back and forth on it. It took it another step and says, was not required. That's not supported, and I'd like to know if it is. Where is that evidence that indicates it was not required beyond the testimony, the naked testimony, he didn't receive it? Was there any other evidence?
Judge Ray, may I respond? I'm past my time.
Oh, you may.
Was there any other evidence, yes or no?
Your Honor, there wasn't any evidence specifically mentioned by the immigration judge. However, that and everything else isn't evidence of the severity. There is zero
I don't want to belabor that.
severity.
I'm not talking about evidence mentioned by the immigration judge. I'm talking about, was there any other evidence in the record beyond the petitioner stating, I did not receive evidence of treatment? Was there anything else that would support saying was not required? That's a yes or no answer.
Yes. There
Okay.
was the fact that the mother identified, looked at his bruises and sent him to somewhere else in the country just a few days later. The fact, all of those things, the fact that he came home after the meeting, all of those things tell you that there's no evidence of severity, zero evidence about severity, and on that basis, Mr. Portillo Flores failed to establish past persecution. He failed, and that's what the immigration judge held.
Thank you, Ms. McLaughlin.
Thank you.
Mr. Hughes, you have some time reserved.
Thank you, Your Honor. I'd just like to begin with one general point and then briefly touch on 3 points, if I may. The general point is that the government's argument rests entirely on asking the court to draw conclusions that were never reached by the agency. And that brings us to the fundamental point of the petition, that when the agency applies the wrong legal standard, does not reach conclusions that adequately support the result that it reaches, and does not fairly address the record. If any of those three things occur, the court just does not get to substantial evidence, and that is a necessary basis in order to vacate. The three specific points I'd like to make are first touching on the standard.
Mr. Hughes, can I, Judge Diaz, can I ask a question with respect to that? So if that's right, is it, and I noticed at the end of your supplemental brief, you said at a minimum, this case should be vacated and remanded back to the agency for further proceedings. What do you mean by that at a minimum? Are you suggesting that this record, the record in this case compels but one conclusion with respect to the issues that we've been talking about this morning?
Yes, Your Honor, that's our alternative. At minimum, the legal errors require vacatur, but I think the court could proceed to find that the Elias Zacharias standard is satisfied, that the only reasonable conclusion a fact finder could meet in these circumstances is that there was past persecution and reverse. So the three legal things I said earlier, that's the distinction between, of course, vacatur and reversal. If the court were to rely on just those bases, vacatur would be
Mr. Hughes, did I just hear you say, maybe I misunderstood, are you saying on the inability and unwillingness to control, the record only supports one conclusion, and that the government was unable or unwilling to control? Are you saying on that issue the record only supports one conclusion?
Yes, Your Honor, that is our position. Now, if the court agrees with us, that would be a basis to reverse. If the court disagrees and thinks that reasonable minds could come to a different place, then that would be a position where the court should vacate. And I think that would be the touchstone in the resolution of the case if the court is disposed towards petitioner on that issue. To the specific points I'd like to raise on past persecution. First, I think as the court appreciates, the agency applied the wrong standard of equating medical care as a necessary requirement. Further, on the death threats, the government makes clear that they seek to overturn dozens of this court's cases.
Mr. Hughes, I asked your colleague the same question, and you fall into the same pitfall. The question isn't whether somebody sought medical care. The question is whether there was an assessment of the injuries based on the conclusion that medical care was not needed for that injury, regardless of whether they sought it. Just a minute. And in this case, the record shows, with respect to the last beating, that there was bruising, which was observed by the mother, and nothing further. Indeed, there was evidence that he carried on otherwise with respect to what he was doing in life without the need, not whether he sought it, without the need for medical attention. And so at least the fact finder could reach that conclusion. Now, if you say that's too thin, it seems to me it's still the burden of the petitioner to show it, or at least you'd have to give the IJ the opportunity to explain further if you wanted that.
Your Honor, two things. I don't think the fact finder could conclude that based on the threats and the death threats that we can touch on. But even if a fact finder could, the fact finder simply did not find that here. The fact finder rested on a legally erroneous understanding of what persecution is. So that, at minimum, requires a vacatur. But I think reversal is found in the full mosaic of circumstances here. The beatings where he almost died, the repeated threats, the death threats that are made to his sister and his mother, because threats to family directly bear on the objective and subjective prongs of the persecution analysis. And finally, the death threat.
Does this put us back at the question, even if we accept where Judge Niemeyer is going on this, that effectively what we're seeing is that the agency made up a new legal standard under which the physical harms can be said to qualify as persecution only if they're severe enough to require medical attention. Where does that exist anywhere?
It does not. And both the Third Circuit and its Doe and Blanco decisions looked at identical language that the BIA and the ALJ used and found that it was a made-up mechanical standard that had no basis in asylum law and rejected it as legal error.
So, Mr. Hughes, I think Judge Wynn makes a good point that if there was a standard, a legal standard required that required medical attention, that might be a legal standard. But it seems to me there's a difference in pointing to a fact that the injuries did not need medical attention that supports the legal conclusion that there was not past persecution, and saying that because they pointed to the fact, they've therefore established a standard.
Well, I think the language here, it was based on, the ALJ said quite squarely that there was no medical attention that was received or required, and based on that fact alone, led to its conclusion that there was no past persecution. I think that squarely adopts the standard, and there was certainly no discussion of any of the other relevant.
Mr. Hughes, if I could follow up a little bit on that. There's no testimony in this record from a medical professional, a doctor or a nurse, as to whether a medical attention was required. So could you tell me, in the absence of any evidence from a medical professional as to whether medical attention was required, how can we conclude that this is a correct standard? A conclusion that no medical attention was required when there was no medical testimony?
I think that's right, Your Honor. And as the Third Circuit has said, there is no such mechanical or checklist formula to assessing when circumstances rise to persecution. Here, where an individual, a 14-year-old boy, was beaten to the point where he testified credibly found that he almost died, and we know that there were death threats that were directed to him. To my friend's point that he learned of those death threats later, that's irrelevant to the analysis of whether he was at objective risk. And further, as my friend, I believe, appreciates, all what we're trying to assess here is the future risk that Mr. Portillo faces if he is returned to El Salvador, and those death threats, having never been retracted, certainly bear on that, both on past persecution and future persecution, and they were discounted by the agency for the sole reason that they were uttered to his sister rather to him directly, which this court in Diaz de Gomez, in a footnote, rejected that directness requirement. The full matrix of events here, I think, compel the conclusion that there was a persecution, at the very least, would be required.
Mr. Hughes, if I may, your colleague on the other side, with respect to this issue of death threats and our cases that address this question, seem to suggest that we have sort of an ironclad black letter rule that in the abstract, with nothing absent anything more, that a death threat standing alone is sufficient to make a finding of past persecution. I don't understand that to be your position, right? I mean, you've got death threats plus a lot more here, at least that's your point. But do you read our cases the same way?
No, Your Honor. This court's cases, I'd point the court to Cedillo, a 2020 decision, which says it's quote unquote credible death threats. And then more recently this year in Diaz de Gomez, the court said that unspecific or distant death threats would not qualify. The whole question here is whether those are credible. And that follows directly from the Supreme Court's decision in INS v. Stevick, where the court said that the meaning of persecution is broader than a threat to life. If you have a credible death threat, that is per se a threat to life, which the Supreme Court's own definition and understanding of persecution would fairly fall within. So I think this court's precedent.
Mr. McLaughlin says that those death threats have to be conveyed to the child. The death threats were made when he was 14 years old to his sister, and Mr. McLaughlin says that can count because he's a 14-year-old child and he didn't know it. Now, is that a correct proposition that Mr. McLaughlin's marketing here?
No, Your Honor. The court Diaz de Gomez squarely rejected that, and for good reason. And I think we can appreciate why a family might not tell a 14-year-old young teenager that MS-13, a notoriously murderous gang in El Salvador, has issued death threats against him. A family's decision not to share that information with the child, I think, is reasonable, in no way undercuts both the objective risk that he faced, as well, again, the past persecution is all done as proxy for what the future danger the individual would suffer if returned to El Salvador. And a death threat unretracted that he's now aware of certainly has all the indicia that suggest that he has a well-founded fear, both subjectively and objectively so, of persecution if returned to El Salvador, and absolutely establishes that standard. So that he found out about it later and his family protected him in the time, a young teenager, has no bearing on this analysis.
All right, Mr. Hughes, thank you so much. Mr. McLaughlin as well. We can't come down and shake your hand, but please know that we very much appreciate your argument here today. And we hope that you will be safe and stay well. Thank you so much.
The court will take a brief break before hearing the next case. Fourth Circuit.
Mr. Davis, Mr. Kaufman, if you'll please turn your video on and unmute your microphones. Mr. Davis, could you turn your video on, please?
For some reason, it's not, it says host has disabled it.
Uh-oh, let me see if I can, well, I didn't.
Mr. Kaufman, you may proceed.
Thank you, Your Honor, and may it please the court. In this case, plaintiffs challenged the most ambitious mass surveillance program ever deployed in an American city. The AIR program utilizes advanced technology to engage in the mass collection of location information that is organized in digital databases and linked to other on-the-ground surveillance systems that collect identifying images and data. This is a system that, for 180 days, 12 hours a day, recorded plaintiffs and 600,000 other Baltimoreans' movements across their city. Those movements are unique and identifying, and for months, the BPD explained that by collecting them, it would be able to identify suspects, witnesses, an untold number of other people. Indeed, if the plaintiff couldn't, if the program couldn't identify people, it would not exist. And the truth is that this sophisticated system can do precisely what the BPD designed it to do.
Well, excuse me, this is Judge Thacker. The program doesn't actually exist now, though, right? Isn't this moot?
I don't think it is, Your Honor, and it is true that the plaintiffs have now stopped collection, but plaintiff's case and plaintiff's motion is not merely about the collection of new data. Pointing all the way back to plaintiff's request for relief in their preliminary injunction motion, their proposed order, and the briefing throughout this court, they have also sought a prohibition on access to any data collected under the program.
Right, and I understand that all but about 14% of the data has been deleted. And the BPD has also said that, or also canceled its contract with PSS. And as I understand it, they've said that without that PSS contract, they can't even access the remaining 14%. So how does that impact your mootness argument?
Yes, Your Honor. So I think, the BPD has called this a contractual cancellation, but I don't think that's quite right. I mean, even in the letter that PSS, now doing business as CSP, put in front of the court, it mentions that it will maintain the retained imagery, the 14%, in accordance with the agreement originally signed. And so the notion that now the contract simply doesn't exist, I think, is just sort of a false premise here. Second,
to use that data, wouldn't it require to use it in any kind of judicial proceeding? Wouldn't that require the approval of the court? In other words, it seems to me what uses might be made of the data and exactly what kind of approvals it would require. That's all down the road, and it comes back to the point that we're not talking about dismissing the entire case. We're just talking about dismissing the appeal, which is a very different kind of thing. And I think we can only speculate it, because if the data is being used in some kind of impermissible way, a court would suppress it, or someone would raise a point of law in a separate proceeding. But I don't understand the existence of the data or the potential future use of it to bear upon the very, very limited question here, which is whether we should dismiss not the whole case, but simply the appeal.
Yes, Your Honor, thank you. I think that, first of all, the standard that both the Supreme Court and this court has put into place in terms of when a case is moot it just isn't reached here. And that's because the plaintiffs can still get relief on their motion, which is the subject of this appeal. So in Chafin and Raymond from this court, the standard is whether it is impossible for the court to grant effectual relief. And again, the plaintiffs are asking this court to impose a restriction on the BPD's access to this data. And just one point in connection with that, and Judge Harris, I want to get.
Well, why wouldn't the district court be the one when they're talking about restrictions on the data? There's some factual questions surrounding that, and that is, what is the data? How extensive is it? What proposed uses are there? What contractual inhibitions are there on using it, or any other? I can think of a number of questions that still need to be answered, and I just think it just is odd to me. What relief can we really grant here? We're being asked to enjoin a program which is defunct. We're being asked to enjoin something which no longer exists to be enjoined. The Supreme Court has said that these doctrines of mootness are not rigid, that they are supposed to have a practical and flexible dimension. And when the only relief that's being requested here is that of injunctive relief, and that which is sought to be enjoined is no longer in existence, why isn't that just, doesn't this render the appeal, not the case, but the appeal, moot?
Yes, sir. Well, respectively, I don't think that this is a defunct program. The department has represented it maintains 14% of the data it collected throughout the 6-month period. And again, plaintiffs are asking to restrict that access to that data. And again, plaintiffs
but why, Mr. Kaufman, why? It seems to me this is an ongoing case, and it's before the district court, and the district judge has full jurisdiction to address all the changed circumstances. But we have the Board of Estimates has voted to cancel the program. The mayor, who's newly elected, has vowed that under his reign for 4 years, it will not be revived. And so that we have new circumstances, and you're asking us to issue basically a preliminary injunction pendente lite on facts that are not in the record, that are coming to us on appeal, and nobody's made any fact finding. If there's further relief needed, why couldn't the district court give it to you?
Respectfully, Your Honor, I think just to make the point, I want to go to the merits just for a moment. Plaintiff's claim here is that this data from day one was unconstitutionally collected.
I understand the data issue. But the data issue is even changed in circumstances where the bulk of it is deleted and 14% is somehow, and we don't know the full details of that, is somehow preserved for ongoing criminal investigations. My question is, these changed circumstances have not been aired. And if we were to issue any kind of substantive order, we'd be preempting the district court. The district court has this case, it has all the facts, and you can present new facts to ask for an injunction and say an injunction is all the more needed now. But to come to us and ask us virtually to enter an injunction on facts that were not before the district court and is never considered by the district court, and we're supposed to consider in the first instance, it's very unusual, I think.
Your Honor, I agree that the passage of time in this case makes this situation a bit unusual, but the record here is the record that existed at the beginning of the case. And again, plaintiffs claim, the issue before the district court was a pendente lite injunction. That means holding things in place or not, just pending the litigation. And the court had a whole circumstances. They were flying the airplanes, they were collecting data, but now we have a whole new set of facts. Your Honor,
we have to now decide whether we should issue an injunction in a case in which the district court is managing. and under entirely new circumstances, which I've never seen anything quite like this. I mean, it's a...
Your Honor, respectfully, I don't think the circumstances are so new. And let me just, if I can just explain the plaintiff's claim a bit. Plaintiff's claim is that by possessing this data under Carpenter, that data reveals the privacies of life, and therefore the department never should have had it in the first place. And so whether plaintiffs were successful at the outset and prevented the planes from ever leaving the ground and collecting one picture, or whether this appeal or the litigation in the district court over the PI took a month or two.
Well, the district court's opinion really wasn't addressing this whole point of the data. It hasn't even had a chance to address the collection of data or anything else about it. I mean, I have to tell you, the whole thing just strikes me as a bald address, a bald invitation to issue a completely advisory opinion, and a case of controversy is what enables us to do that, and this makes me feel somewhat silly, as if I'm being asked to have something, to hand in something or to draft some opinion that I might as well be handing in a third grade essay for all the practical effect it has. And it's just an odd position to put a court in. It really is. I just feel silly.
Your Honor, respectfully, I don't think it's silly to ask for relief in this case right now for the plaintiffs. What plaintiffs have alleged—
What is the relief you want? What is the relief you want specifically?
The relief is an injunction enjoining the BPD from accessing the data it is already collected under the program preliminarily as the litigation continues in the district court. And again, that plainly meets the standard in Chafin and in Raymond in this court.
Where is the data now? Where are the 14%? Where is the 14% data that they've retained?
According to the representations of the department, the PSS is holding the 14% of the data. And again, on the 14%—
Just a minute. Let's stick with that. Let's stick with that.
Sure.
They're holding the data, right? Is there any threat of that data being issued to the public or anything else other than in accordance with a court order?
Yes, Your Honor, absolutely. Without an order from—
What's the evidence of the threat right now?
Well, I can just point to what the department did last month was amend the terms of their contract to change the terms of access. And also in that statement—
But we're not under the contract. Even the funder has said he's not going to fund it anymore. The chances of the contract being resurrected, it seemed to me, are almost nil. But that's irrelevant in a case where we have an interlocutory order. This order was just an interlocutory order temporarily entered. But the case is still before the district court, and everything you're saying can be presented there.
I don't think that's quite right, Your Honor. And again, the department is maintaining this data. They hold the data. And on the 14% number, it sounds like such a significant thing that the department did. But remember, under the terms of the contract—
The two critical questions, or two of the critical questions with respect to the data, is who has access? Who, if anyone, has access to the data? And what uses is the data proposed to be put? Now that was not before the district court. The district court, its opinion dealt with the features of the program. It went through the features of the program and why it thought the program didn't warrant the entry of a preliminary injunction. But the data, to the extent that it was discussed at all, was very much a subsidiary point. The whole question before the district court was the program, and that program has been discontinued. And that's why the appeal should be dismissed and leave to the district court the factual questions it never considered and that we are in a poor position to consider, which is, what is the access? What access is there to the data? What exactly is the nature of the data? What uses is the data proposed to be put? When can those uses be contested? All of those questions surround the data, and none of them did the district court focus on, because it was rightly, under the circumstances existing at the time, focusing on the way that the program worked. And now the whole focus of the district court's opinion has shifted dramatically because the program is no longer. And it's just odd to be asked to enjoin something that doesn't exist. That would seem the very definition and the very essence of mootness.
Your Honor, the program exists because the department continues to possess data that on plaintiff's claim was unlawfully collected, unconstitutionally collected, and the department never should have had it in the first place. And the relief that plaintiffs are, yes, Your Honor.
Counsel, can I just ask, I hope a narrow factual question, and you can just point me to the JA. 14%, is there record evidence suggesting that these plaintiffs are implicated in that 14%? Understanding that somebody is implicated in it, where would I look to see whether these plaintiffs had some interest in or some exposure in the 14% of the data that was collected, the crime scene data?
Thank you, Your Honor. We have not, there is no record evidence about what data the department has actually collected. I will mention, I don't think the department absolutely has not represented that the plaintiffs are not among the 14%, and I don't think they could for all intents and purposes. But again, your question raises another point that I was trying to get to earlier.
You don't think they could? You don't think they could because they don't know, or because they now don't have access to the data, and so there's no way for them to know one way or the other?
Forgive me, I misspoke. They absolutely could if they decided to go in there and start looking around for the plaintiffs. And that
why is that a question for the district court, whether the plaintiffs have any longer an interest? But that's not a question which bears on the dismissal of the appeal. That's a very good question, but it probably bears on the ongoing viability of the case. But once again, trying to discern at this level whether the plaintiffs have the interest, and if not, which ones do and which ones don't, and which ones should be dismissed. Shouldn't that be thrashed out? It's a good question, but shouldn't it be thrashed out before the fact finder?
Your Honor, I just want to try to finish a point that I've been trying to make, which is that under the terms of the program, the department was only retaining 45 days of data at a time. 45 days out of 180 is 25%. At the outset of the case, and the panel, the district court, everybody has agreed that the plaintiffs had a sufficient stake in the litigation at the outset to allege that they would be caught up. Indeed, it would be silly to assume that they would not be caught up, because any Baltimorean that went outside during the course of the program was going to have their movements recorded. And now what the department is representing is that they have gone from 25% to 14% of the data held. But if you and I appreciate the passage of time here makes this a little bit difficult to understand, but if the plaintiffs had properly alleged that they could seek injunctive relief prohibiting collection and access, which is what they did at the outset of the case, as to 25% of the data, they have the same claim as to 14% of the data. And again, I just want to emphasize to the court here that this is a preliminary relief that the plaintiff is asking for. And again, if any permission is, a couple of your honors have mentioned the department needing now permission to access it or do further tracking. An order from this court declaring that the plaintiffs are likely to succeed on their Fourth Amendment collection claim, and that in order to access data further, the department needs to go to the district court and ask permission to seek relief from that injunction. That is precisely what the plaintiffs are asking for, and it would give them what they want at this stage of the litigation. Obviously, it's not the entire ballgame. Plaintiffs wish that this bill had been heard earlier, that we had been successful before the district court. But the only reason now that the planes are down is because of the passage of time. But again, the department maintains access to this data, and PSS is the one holding it. But again, nobody has argued in this entire litigation that PSS is any differently situated than the department itself.
Mr. Kaufman, excuse me, this is Judge Motz. Can I just go back to Judge Thacker's question, which I thought was a very, very good question. So more than one judge is asking very, very good questions. And that is whether we know in this record, whether the city has access to it?
I believe the answer is yes.
I know
Your
you're
Honor.
claiming that that's part of your claim, that they shouldn't have access.
Yes, I believe by possessing the data, that is really what we mean by access. And that
But
relates
I
to the
think that Judge Thacker's question went to, well, she had thought that there was no ability for the agent of the information to get it anymore, and therefore no ability for the city to get it anymore. And I wasn't sure about that. So maybe you can.
Yes, Your Honor, thank you. I think that that's mistaken because for a couple of reasons. One, the department already has data related to 200 ongoing investigations. So it already possesses imagery that relates to all of those investigations. And there's no reason to think that that imagery, which it contains imagery from days that happened, would not include the plaintiff. So the department.
No, I'm not going to the question about the plaintiff. I'm really going to the question to access, the access question.
Yes, Your Honor. So the access question, I think the department maintains now that according to the amendment that it made to the contract, that it has no present intention to access the data to conduct any new tracking. That is what it has maintained. But again, there is nothing stopping the department. First of all,
I thought it said it not only had no present intention, but no ability to meaningfully access and utilize the information.
Your Honor, I think.
And I guess they can speak to that, but.
Yes, Your Honor, I think quite frankly, that's something of a sleight of hand because it's sort of pushing off onto PSS the sort of idea that there is access. But because PSS is the BPD for the purposes of this litigation, and nobody has argued otherwise. Again, another thing that's relevant under this supposed argument that they can't access the data anymore is that even in the same breadth that they maintain that they don't have access.
How could you make the statement that PSS is the same as the department? It seems to me
because
they were functioning for the department, and the relationship today is unknown to us.
Your Honor, the BPD has not argued, and no court, the district court or the panel, has even come close to suggesting that that PSS is not a state actor under 1983 for these purposes.
We're not talking about whether state actor. I'm talking about whether what PSS collected is available to the city. In other words, we don't.
Again, Your Honor, I was just about to get to that.
We don't know the circumstances of the present circumstances of the status of the data, who's holding it, who has a right to it, and that is all could be developed by the district court if there's another threat.
I don't think that's correct, Your Honor. What we know about the status of the data is what the BPD has told us, which is that they hold 14% of it. And again, in the same statement where they say we've deleted all this data, this case is moot, the city solicitor in the same moment that he voted to amend the contract said now the case is moot. Okay, in the same statement, the BPD says we reserve the right to access this data for prosecution and to give access to defense counsel in cases where constitutional obligations exist. And so without an order from this court, and of course, plaintiffs don't want to interfere with defendants' constitutional rights here, but the court could issue an injunction saying, okay, this is what you've promised. We're going to formalize that through an injunction, and we're going to make, yes, Your Honor.
Judge Rushing on the audio. Hi.
Yes.
I had a question about what you're talking about now. That gave me the sense that the balance of equities is perhaps different now than it was when this was before the district court. You're asking us to enjoin something different, and I'm not sure how to balance those equities, but I'm not sure that I should be doing that in the first instance on appeal, because it does raise this tension between perhaps criminal defendants and your clients while the case is pending. And that seems like something to me that should be sorted out in the district court, but I don't know if I wanted to get your views on whether these other winter factors are different now.
Thank you, Your Honor. I think it's an excellent question, and you know, I will concede that because collection has stopped and because some of the data has been destroyed, that the sort of balance has changed a little bit, but it has changed on the other side as well, because the department now says it has no intention to access this data. So the injunction that the plaintiffs are asking for, according to the VPD's representations, would virtually have no effect on their present intentions. certainly they could apply to the district court for relief from that, and plaintiffs are willing to work with them in particular if there's particular needs for access to data. So I think that the balance.
You may be completely right about that. I think you're making good points. My concern is just that we would be undertaking this in the first instance, trying to figure out how these interests balance in this new state of affairs. Whereas this seems like maybe something the district court should be looking at and evaluating in the first instance.
I respect that, Your Honor, and I think the district court will have a lot to say about the contours of any injunction handed down by this court. But if your point was taken all the way, it would mean that any time an appeal comes up to the court where time has passed and the equities have slightly shifted, the court could never decide that in the first instance. And again, the panel decided this case with days left in the collection of the program. So it's not as if this court en banc would be doing something dramatically different than the panel had done. When it decided.
But you're not giving up any rights if we simply dismissing the appeal. You have all your rights, and if you don't like the uses to which you think the department is putting the data, and you don't like who has access to the data, and you don't like the consequences, you can bring another appeal. Or, Your Honor, you know, if it's a particular prosecution of somebody, you can file a motion to suppress. But I don't understand, given the fact that simply dismissing the appeal doesn't forfeit your rights to bring another appeal if you're dissatisfied with the answers that the district court has given. I don't understand what rights the dismissal of the appeal, what rights are you possibly giving up that you can't assert before the district court in another appeal or in an individual prosecution if it's ever used in that way? And I have no idea whether the data would or wouldn't be. I just don't understand how you're being prejudiced by the dismissal of the appeal.
Your Honor, just a few responses if I can.
Counsel,
dropped off a few minutes ago.
Yeah. We're just missing Judge Thacker. I was just trying to get us to pause for a moment.
Oh, thank you, Your Honor.
Stand by.
Thank you, Your Honor. So Judge Wilson's question was again about how a lack of injunction from this court would harm the plaintiffs. And again, plaintiff's claim is that the department now possesses unconstitutionally collected data, and without an order from this court prohibiting them from further destroying, further accessing, further distributing, they're free to change the contract, just as their actions last month proved.
I can't see all the judges.
Sorry, Your Honor, are we all?
Who was talking?
Fine, I apologize.
All right.
So the plaintiffs do require an injunction from this court to pause things, and we're willing to move very quickly. We have no intention to, interfere with government investigations that are ongoing. We want to go to the district court and resolve sort of how particular requests for data could be resolved, and I think that's an appropriate thing to remand. But I just want to make, if I could, sorry, Judge Keenan, one moment. I just want to make one point, which is that there's a lot of suggestions. Sorry, go ahead.
Yeah,
go ahead.
Thank you. Mr. Kaufman, I'm trying to understand your full answer in terms of what you will be losing if you do not get your preliminary injunction. And I'd ask you if you could answer that in the context of our Fleet First versus Nike case. It seems to me that here where you have a denial of a preliminary injunction. Arguably, you were in a different position than the situation in Fleet First, where the injunction was granted. But going back to Judge Wilkinson's question, it seems to me that you have to argue really that the city could restart the program in the interim or make it.
I think there's a.
The fact that the fact the city did change its position back in 2016, right? Factually, it restarted the program.
It did. I mean, I think that's a very.
What you're relying on to distinguish this case from Fleet First versus Nike? Because I'm trying to get the.
No, Your Honor. Thank you. I think that there's something in your question about restarting the program. And again, I just want to be as clear as I can. The program is ongoing. The department maintains this data. They are not newly collecting data. And I don't think that plaintiffs' demand or request for an injunction here and their argument on mootness of this appeal really hinges at all on whether the planes will fly again. And that's not a consideration in the mootness, in the straight up mootness.
Part of your argument today, the fact that they could go back to 100% operation during the pendency of the case in the district court. You're only current operation.
I'm sorry. Yes, that is not part of our argument on mootness. If the court were to decide that, yes, the existence of the data is irrelevant, the case is completely moot, I think that the potential to restart the program might come in as a consideration under the exceptions to the mootness doctrine. But I don't think they're relevant to mootness itself, because that's just about whether it is impossible for this court to grant effectual relief to the plaintiffs. And I hope I've been clear enough that there is an injunction that this court could issue that would absolutely preserve the constitutional rights of the plaintiffs while we go back down to the district court. And
shouldn't you ask the district court for that now? In other words,
Your Honor, we already asked the district court for that
Just a minute,
injunction.
Mr. Kaufman. Let me ask my question, please.
Sorry, Your Honor.
The question is, we have a whole new set of circumstances that have to be weighed. In other words, what is the status of the data? What is it being used? What are the restrictions on it? Who has access? Who doesn't? And those were not considerations that faced the district court in the order it entered. And the order it entered is the one before us. So now if you're asking us to issue an entirely different and new injunction than was issued by or consideration that was then was considered by the district court, wouldn't it be the most pragmatic thing to let the district court hear you out and decide whether to issue an injunction, and at that point, give you the right to appeal? But in the interim, you could develop the facts. We don't really know the facts. We're having assertions being made in the newspapers and in letters and briefs without record support. And it's an awkward situation for us to reevaluate all the circumstances and apply all the equities when the district court has never done so. We're supposed to be reviewing the district court, not initiating equitable relief on appeal.
Your Honor, respectfully, the plaintiffs asked the district court for the precise injunction that they're asking for now. Of course, we also asked for an injunction barring collection. So yes, to some extent, you're right that sort of has gone by the board. But the plaintiff's request for relief in terms of pausing the government's
don't you understand that the request for not using those data in your original injunction was under a circumstance where the contract was operating in full force and effect, and you could look.
I don't think that has changed.
Sir, just a minute, sir. You could just look to the contract to see what the rights and liabilities. But now you have new circumstances. You have the funder who is withdrawn. You have the contractor, which we don't know the rights vis-a-vis the city. We have the city maintaining it. We don't know the restrictions. And we have the most of the data destroyed, 86% of the data destroyed. And the question is whether these plaintiffs participate. All these questions are probably good ones, and they may entitle you to an injunction. But at this point, regardless of the doctrine of mootness, the whole subject matter is different. That's before us.
Your Honor, I respectfully, I do not think that that is correct. The plaintiffs have claimed that the department and the department has represented that they maintain this data.
Counsel,
Yes,
Counsel, it's Judge Harris. I'm sorry. I feel that I may be missing something important here, and maybe you can clear it up for me. I don't understand. If you go back to the district court and say the circumstances have changed in the way Judge Niemeyer described, isn't the district court just going to say, why are you here? I already told you lose on the merits? Like, I don't understand how you can go back to the district court and ask for a different and narrower injunction. He didn't rely on that. He relied on the fact that you lose on the merits. What's the point in going back?
Thank you, Your Honor. That's a point I've been trying to make for the entire argument, which is that there's a pending motion to dismiss in this case. So when we go back down, we are not going to have 6 months of discovery about, figuring out whose data is collected and how much and who has access. We are going to have the exact same legal presentation on the exact same record. And the court, without guidance from this en banc court, is simply going to re-enter its order on a motion to dismiss. We're going to go through appeal on the panel, and we're going to be right back before the court on the same exact.
That's not necessarily true, because what the district court, the district court did was deny a preliminary injunction, and there's a big difference between a preliminary injunction and a final injunction. And one of the things that was troubling was we were asked to reverse the denial of a preliminary injunction, and even as to the merits of the program, the record was awfully thin. It was a relatively slender record for something of this sort, and we have all sorts of factual disputes about how the program works and what it does and what it doesn't do. And to say that the district court is frozen and that it's a foregone conclusion that the district court is simply going to again deny relief, I don't see how you can say that, because the point has been made over and over and over again that a preliminary injunction is just what its name applies. It's a preliminary ruling. It's not a final ruling. And the point, and it pertains not only to the mootness point, but also to the overall case, the district court, if we reverse the district court for abuse of discretion, for denying preliminary relief, we're cutting him off at the pass, and we wouldn't even have given the district court the chance to develop a full record on the merits of the program. I mean, there are all these questions about the data, but there are also a slew of questions having to do with the merits, which haven't been developed and which often are developed by trial courts in that interim between preliminary injunctive relief and a request for final injunctive relief.
Respectfully, Your Honor, the district court decided the likelihood of success prong by saying plaintiffs on the record before the court, which was the defendant's contract. And again, I understand that some members of the court might think this is a sparse record. Actually, the department laid out on paper exactly what it was going to do. And we have the same record today that we did back then. The court said that it did not believe that the plaintiff's data would be unconstitutionally collected under the contract. And therefore, the question today is whether it has been collected unconstitutionally. And so even granting that Chief Judge Gregory's dissent was particularly persuasive, I don't think sending the case back down to the district court to decide a motion to dismiss in which the court will decide whether plaintiffs have alleged a constitutional claim is going to result in any kind of different analysis. And that's why this court really does. I think I've made the point that the case is not moot. The court has taken it en banc. The district court needs guidance on this question. And therefore, it is entirely appropriate for this court to issue an injunction. And if the court feels—
But why are we having factual disputes on the very basic point about how it even operates? You've got all these amicus briefs saying, no, it operates one way, and you've got other briefs saying, and the city saying it operates another way. I mean, that's ripe for factual development as well.
I'm sorry, Your Honor. Your Honor,
no, please, you go ahead.
I agree that the amicus briefs and now the developments that the department itself has introduced in the case have introduced some factual questions. I do not think they are material or relevant factual disputes for the purposes of the legal question. The legal question is, under the Fourth Amendment, can the department put planes in the sky for 180 days and record the movements of everyone below? That's the question. And what the department does with it afterwards, as long as the department has the data, and it does, it admits it does, that legal question is important to the plaintiffs because it determines whether for 6 months their location information was unconstitutionally collected, and it now, presently, is unconstitutionally in the possession of the department. And this court can grant limited injunctive relief at this stage, saying, okay, BPD, you have now said that this is the state of play. You're not going to access it to track new individuals. You're only going to access it to further investigations or to give constitutional rights, to defendants in criminal cases. This court could say, okay, we're going to order you to do that, because right now the government is not under any obligation, any legal obligation, to treat that data in any way differently than it wants to, and it could change the terms tomorrow. And so this court absolutely can intervene now with limited relief if it would assuage the court somehow to put some sort of time, clock on what the remand, the shape of the remand and the speed with which it needs to take place. Plaintiffs would welcome that. That would be, we would love to. We've been wanting to go back to the district court since April. So we would love to.
Wouldn't all these points you're making have somewhat greater salience if you were being thrown out of court? But you're not being thrown out of court. You're not being prohibited from raising any question that you've talked about for the past 30 minutes or so. You can raise them all.
Again,
we're talking about a very limited thing here, dismissal of an appeal.
I respectfully understand that this is only part of the case. But again, we have already asked for the relief. You're suggesting that we should go back down and ask for it. We've already asked for it. It's before this court. And again, I think it's relevant that the motion to dismiss is pending. We are not going to come back to this court with a more fully developed record and discovery and depositions of the NYU team. That's not going to happen. We are going to come back on the same exact legal question. And I don't think that it's sensible at all for this court to dismiss this appeal on those grounds with the expectation that a new...
I don't think you know that. That's truly speculative.
Do you have discovery you want to take, do you not? Don't you have discovery that you want to engage in?
We would love to engage in discovery, but...
And under Rule 65A2, a hearing on the trial of the merits can be consolidated with a hearing on the preliminary injunction. But that was never done here, was it?
No, we filed a motion for preliminary relief on the same day we filed the...
Well, right. But so before or after the beginning of the hearing on the motion for preliminary injunction, the court can advance the trial on the merits and consolidate with the hearing. That is, the hearing on the preliminary injunction. That was never done.
Your Honor, I don't think
it even mentions the fact that the court must preserve any party's right to a jury trial. So a question of a permanent injunction is reserved and would only be, that would be the trial on the merits, and that would be after discovery is completed.
Your Honor, unless I'm misunderstanding the rule, I think that we're not talking about going back down to have a trial on a permanent injunction in this case. We're talking about going to litigate a motion to dismiss. And so it really is not about going back down and developing a record and then coming back with a retrospective record that tells us everything we want to know.
You're not going to concede the motion to dismiss.
Of course not, Your Honor. But
you're
again,
going to litigate a motion to dismiss.
Your Honor, respectfully, I think Chief Judge Gregory's dissent was quite powerful, but I don't expect the district court to change its mind, and we're going to end up back on the same exact legal question. And the department is not going to realistically allow us to engage in discovery pending
But if you lose the motion to dismiss, then you can take an appeal on a final order appeal.
That's correct, Your Honor. And we're right back before
come up here and you say we were denied the discovery, and he was wrong from a legal standpoint. And here you haven't had the discovery yet. You're only up here you're here on the preliminary injunction denial.
Your Honor, I think that it's virtually impossible to expect that the district court is going to do anything other than re-enter its legal analysis, dismiss the case, and send us back on appeal here. And there's absolutely no way that we're going to be engaging in discovery while the case has already been dismissed. And we're just going to come back right here on the same exact legal question.
Are the material, you're saying the material, are you going to concede that the material facts are the same now as they were at the time the district court ruled?
For the purposes of preliminary relief and the purposes of our complaint satisfaction of the pleading rules and stating a legal claim, yes, absolutely, they're identical.
Well, I'm surprised you said that.
I'm not sure why, Your Honor, because our complaint alleges things about the program that the department wrote down in a contract, and that is the record. And when the department filed its motion to dismiss, it made its arguments based on the same record, and it made its arguments based on really, this case is about the Fourth Amendment claim, Your Honor. The facts, how things are handled, they're relevant to subsidiary claims, of course, but the real question here is when Baltimore Police Department puts 3 planes in the sky and records people below for 180 days, does that violate a regional expectation of privacy under the Fourth Amendment?
Mr. Kaufman, can I ask a question? Judge Diaz here. So some few minutes ago, you sort of set out the contours of what sounded like a reasonable stipulation or order regarding maintaining the status quo, but you would ask that you're asking us to enter that order. And of course, we couldn't do that without making a finding as to the likelihood of success on the merits, which is, I can understand why you would want that. But I guess the question I have for you is, have you sought such a stipulation from the city, which essentially would simply memorialize what appears to have already happened on the ground? And if not, why not? And I'll ask Mr. Davis the same question, because ultimately, even if we were to grant you that relief, and you keep saying the only thing that's going to happen is this case is going to go back down to the district court for a finding on the merits, but that's going to happen regardless. Even if we were to grant that order, it's going back to the district court. And if you lose, as you think you seem to believe that you would, it would come right back up to us. So that's a 2-part question, I guess, is have you sought a stipulation that would eliminate the need for the court to enter an order? And isn't the case ultimately going back to the district court in any event?
To answer your question, Your Honor, we have not sought that kind of stipulation. I think that one relevant point here is that the department does not believe, it has not considered the illegality has happened at all. It thinks what it has done is completely free of regulation of the Constitution. And so,
well, it wouldn't have to concede anything. It would simply just say, hey, for purposes of litigation, we're going to maintain the status quo, enter a stipulation, and let's move forward.
That's correct, Your Honor. I think that is true. However, if this court doesn't address the likelihood of success prong, we are going to end up deciding the same or debating the same exact question again. And I think it's relevant that the court can right now, in a case that is not moot, decide that question and give the district court the rule that it needs to apply to the rest of the case. I just think it's a waste of judicial resources, it's a waste of judicial economy, it's a waste of this court's time to say, well, we're just gonna send it back down and go through this entire process again when we know that the district court is just going to follow the rule that it believed was correct and that.
No, but that's not the way the law. What you're asking us for essentially is a per se rule that district courts who have issued preliminary or declined to issue a preliminary injunction or who have issued a preliminary injunction, you're asking almost for an absolute presumption that they're going to rule exactly the same way on a motion for a permanent injunction. And I really think respectfully that disserves the district court and its role, because a permanent injunction, a preliminary injunction and a permanent injunction as a general matter has a much fuller record. The record here, as I understand it, was less than 100 pages, which is pretty short for a case of this importance. But if we were to say in every case where a preliminary injunction is issued and it comes up, or every case in which a denial of a preliminary injunction and it comes up because it's an appealable order, if we go the way you want, we would have to indulge an unrebuttable presumption that a district court that ruled one way as a preliminary matter was inevitably going to rule another way when the request for a permanent injunction came up, no matter what the development of the record had demonstrated in the meantime. And that's just not the way the law reads. The law recognizes a difference between these two forms of relief, preliminary and permanent.
Your Honor, I just to be clear, there's no legal rule that I'm suggesting, but that there's an unrebuttable presumption that the district court's going to rule the same way. We're talking about this court's equitable jurisdiction, the equities involved in issuing an injunction now, and merely as a practical point, I've suggested that the court is highly likely to follow the same legal analysis it issued before, unless this court corrects it. Your Honor, I don't think that should be such a controversial point.
Well, it seems to me it's totally controversial because there's been no trial or no effort to preclude trial at this point in the district court. And the Supreme Court has pointed out how extraordinary a preliminary injunction is in Winter and in other cases. And we have followed that. And the notion that you enter an order without a trial, without discovery, has to be addressed in the way the rules preside. Now, just because it may come out the same way is not a reason to avoid all of that. There is a role for the district court to play. And it seems
Your Honor, I don't
jump in, sir. We should not jump in and preempt the district court from doing what it has to do in the circumstances presented. And I think it's unfair to the court to assume that it's going to do the same thing. There's a lot of circumstances that could rise to the need to issue a preliminary injunction or not. You may be able to show that the data is about ready to hurt somebody. I'm quite sure the district court would consider that and enter an injunction. But to say that because we're going to lose, I predict, we should bypass the whole process is extraordinary.
Your Honor, that's not what we're asking for. We're not saying because we're going to lose, we need this court to rule now. What we're saying is, and again, we're asking this court to issue very temporary and preliminary relief, pause the government's access to this data pending remand. And yes, of course, issue, and in part of that opinion, we would like the court to reverse the likelihood of success analysis. I think it's extremely important that the court has the views of this en banc court in proceeding to the rest of the case, because none of the details that you and some of your colleagues are suggesting are relevant to a backwards looking analysis here, are relevant to the question of, again, the central question, is it unconstitutional under Carpenter, under the Fourth Amendment, to collect 180 days worth of movements of people throughout Baltimore City? Does that impinge on a reasonable expectation of privacy? That question is not affected by the things that have been suggested here today. And I submit that deciding that question now and granting a very limited order on remand, directing the district court to proceed with litigation there, does not preempt anything. It does exactly what a preliminary injunction is supposed to do, which is pause the status quo.
Make that ruling before the district court's made that ruling. The district court has not made that ruling. The district court ruled preliminarily that as a matter of equity, we don't need to enjoin this until the district court consider the issue in the final state and try the case.
Your Honor, respectfully,
a preliminary interlocutory matter like this, when all the circumstances have changed, it seems to me we're in a very poor position to preempt the district court and give them, the district court, the ruling that you want before the district court's made it.
Your Honor, respectfully, that's not what the district court did. The district court said that we have no Fourth Amendment claim, and it explicitly tied the equities under Winter to our failure.
Have you pursued anything in the district court while this appeal is pending?
We have not, Your Honor.
Nothing's been done in this case in the district court. There's no stay in place. There's no stay in place.
There's no stay in place. The department filed a motion to dismiss, and the court issued an order.
But there's no motion to dismiss hasn't been ruled on, and you haven't gone in under Rule 65 and under the discovery rules, and they made a motion to consolidate the case or to permit discovery and to have a trial or anything like that. You have treated the ruling as a final order.
Your Honor, respectfully,
not as an appeal from a preliminary injunction. You've treated it as a final order appeal.
Your Honor, respectfully, I don't think that's right, and I don't think there was much for us to do. We filed this appeal before the planes even went up, and so looking back, I do wish we had taken some.
But it's an interlocutory. It's an interlocutory appeal, correct?
It is, Your Honor, but I respectfully.
An interlocutory appeal doesn't stay the proceedings in the district court.
It doesn't, Your Honor. That's
you have to go in. You have to go in and ask the court to stop it to get a stay.
I'm not quite sure what kind of stay we could have gotten, given that the court did not believe that our plaintiff's constitutional rights were implicated.
You didn't ask for them to do anything or to permit you to do.
Fair enough. Your Honor, we did seek expedited review in this court. We filed an appeal before the planes even went up, and we were granted expedited review. We filed briefs within 35 days, the two parties, and we didn't get an argument.
And that's the way these things are supposed to work.
Of course, I understand that.
Because it's a 1292B appeal. It's not a 1291 appeal. It's not a final order.
I just don't see the practical effect of any request in the district court, given that the district court.
Well, then you say that you don't need any discovery. It's all that the judge's ruling was the final order. Then that's what you be telling us now.
In terms of discovery, if on the central claim of does the collection of this information, which the department now holds, does that violate the Constitution? We don't need any discovery. The department holds the information, and the question is, does that impinge on the reasonable expectation of privacy? There is discovery that may be relevant.
Mr. Kaufman, one question. I don't know if it's final or not, but after this nearly hour-long presentation, can you tell us specifically what is it that you are asking? You says it's limited. So what are you asking before we proceed to Mr. Davis, so we'll know what it is you want?
Thank you, Your Honor. Just to be as clear as possible, we would like the court to rule that the plaintiffs are likely to succeed on the merits of their Fourth Amendment claim under Carpenter, and that the balance of the equities weigh in favor, and the public interest weigh in favor of the limited preliminary relief of pausing through an injunction the government's ability to use that data, to access that data, and understanding that they have already distributed some of it for investigations. I think the court can be creative here as acting in equity if it doesn't want to disturb certain elements of what the DPD has represented, and we can go before the district court and sort of litigate whether.
Thank you. I think I have your point. Thank you.
Thank you, Your Honor. If there are no further questions for the moment, I'll be back in about a half hour. So.
Thank you, Mr. Kaufman. Mr. Davis.
May it please the court, Chief Judge Gregory, Your Honors, Andre Davis for Commissioner Harrison and the police department. It's a privilege to appear before the in-bank court. It's clear, Your Honors, that you understand the commissioner's position here. There is nothing preliminary about this case at this juncture. So we urge the court to dismiss the appeal, not the case. We've never urged any dismissal of the case. We urge the court to dismiss the appeal and remand the case to the district court for further proceedings. Now, if I can make 3 quick points, and then I'm happy to answer any and all questions. Judge Harris, Judge Bennett has not ruled on the merits. Judge Bennett has simply exercised his discretion and concluded through an application of the well-settled 4-factor test for a preliminary injunction that the plaintiffs did not make out a case for a preliminary injunction. So there has been no ruling on the merits of this case.
But Mr. Davis, we all know that one of those factors is likelihood of success on the merits, right?
Correct.
So you're right, but I think that's cutting the bologna pretty thin. But I appreciate you doing this, and I will just ask you this one question. Remember my colleague's very first question when she said whether the city still has access to this 15 or 14% of materials. Does it or doesn't it?
It does, Judge Motz. and it is the material that will be produced in criminal discovery in any one or more of the 41 or so continuing criminal prosecutions that have been developed in part from the program. As of this weekend, there are 6 outstanding arrest warrants. So suspected perpetrators in armed robberies, carjackings, homicides, and non-fatal shootings have been identified in whole or in part through the use of the program. But the program is over. It's finished.
I understand that. I just wanted to reach that one point.
Yes.
And please go on with your
That's
first
the 14%. And Judge Richardson, if I could just respond to your question. I'm not one to predict the future, but it would be astonishing if Ms. Bridgeford or Mr. James, the individual plaintiffs in this case, show up in any of the data still accessible to the government. And as to your point, Judge Diaz, what I expect is that when this case goes back, Judge Bennett will be able to craft an appropriate protective order. And the city and the police department will be happy to turn over to the plaintiffs under an appropriate protective order, perhaps with redactions, the data that continues to exist so that they can examine at their leisure exactly what the city continues to hold, which again is relevant to future and ongoing criminal prosecutions of individual offenders suspected of involvement in this criminal activity.
Mr. Davis, this is Judge A.G. If you could go to the arrest warrants that you mentioned in response to Judge Mott's question, I assume any of those potential defendants could raise a motion to suppress with regard to the aerial surveillance data if they wanted to do so.
Judge A.G., they absolutely will. Every bit as much as Ms. Bridgeford and Mr. James contend in this civil case that the use of the aerial surveillance pilot project violated constitutional norms, every criminal defendant, I would predict, not in the business of predicting, but every defendant whose case was in any fashion touched by this program will surely file a motion to dismiss, to suppress evidence. And those issues will have to be litigated in the course of the criminal trial.
You might also have some motions for Brady evidence that it might help the defendants.
Quite
might
likely,
be exculpatory
Judge King.
also.
But can you make a represent? Sorry, go ahead. Whoever.
Go ahead, Judge Mott. Go ahead.
I was just going to ask if you can make a representation to the court that they never have been used in prior, because I thought these were ongoing cases. You've never used that. So maybe they won't make the claim. Maybe they don't know that it's there.
Oh, they will know because there's an obligation, as Judge King alluded, there's a Brady obligation to turn over this information if it's relevant to a particular criminal case.
Yeah, but we know the government makes that first call, doesn't it?
Well, in this case, we've been called the government.
Indeed.
But really, Judge, this is a part of an investigative technique, innovative and controversial to be sure, but just because it's controversial doesn't make it unconstitutional. Those have never been synonymous terms.
Well,
so the
Judge
data
Davis,
will be turned over. Yes,
Judge Davis, I'm glad you said that because unfortunately today we've gotten to nothing but mootness, and the plaintiffs came here to be heard on the question of whether or not. I'm glad Judge Harris asked the question. It doesn't matter what you use it for. If you use it for prosecution, that's your business, perhaps. The point is, the question asked, should you ever had it in the first place? Did you violate the Constitution by flying planes over your city and collecting it? And now we're talking about, well, we hope that something might happen later. A preliminary injunction is for the question of this, that this is so clear under Carpenter that Baltimore Police Department violated under Carpenter that it shouldn't go any further. They should stop doing it, and also no access, whether it's a criminal prosecution or not. And they came to this court properly to do so. And when the panel heard it, none of this came up about mootness. It was glad to endorse it in terms of using the winter factors. And the majority came up and said, well, it doesn't need it. It's only now, after the dissent and after all those things you call changes, which makes nothing the difference, they're still here saying, we want an answer to that. Is this a violation of Carpenter? If it is, mootness is not a question of finding a way not to do something that you don't want to do. Mootness is a question of jurisdiction. And this court does have the power to answer that question. Did it violate Carpenter? And all this other stuff is red herring about whether or not it'll be used and how long. And that still is the urgent question, and they have a right to be heard on that. Can you answer that? How in the world is this court not empowered to answer that question on a preliminary injunction, whether it meets those factors? And as Judge Mott said rightly, the most prominent of which is a likelihood to prevail.
Thank you, Judge Gregory. I'm happy to engage as deeply into the merits as the court wishes to go.
Well, that's what I'm here for.
The court did answer the question. You and Judge Wilkinson had an incredible dialogue in your respective dissents, in your respective opinions, at the panel level. Very thoughtful, very thorough opinions on both sides. And the court decided to grant in-bank review, which of course vacated those panel decisions. So as we are here today, there is no decision in the case. So Judge Bennett issued an order that said two things. The motion for a preliminary injunction is denied, number one. Number two, the AIR program may proceed. And it was always a 6-month pilot project. Now, my brother on this other side has suggested somehow that the city and the police department nefariously, quickly, surreptitiously brought the program to an end in order to avoid in-bank rehearing. And with all respect, that's nonsense. Brandon Scott was elected the mayor of Baltimore City a couple of days before this court's panel opinion came out on November the 5th. Mayor Scott, back when he was in the city council in 2017-18, and when he became president of the city council in 2019, made it perfectly clear that he was opposed to this program. No question about it. Everybody knew that this program was going to come to an end if Brandon Scott was elected mayor. Everybody knew that. And that's exactly what's happened. The delay, if there was a delay, between the panel opinion, the proceedings on the petition for rehearing in bank, and so on, was because they wanted the actual copy of the Board of Estimates determination, unanimous, 5-0, terminating the program. We didn't need the Board of Estimates approval to terminate the program. The contract, as you've seen, could be terminated for convenience. And the police commissioner had that authority that he could exercise without the Board of Estimates.
I suppose you could start it up at any time you wanted to. Does that matter? You
Not
could
under
restart
this
it.
mayor. Not under this mayor.
Well, I understand that.
Well,
Does the Constitution depend on who's the mayor?
No,
I mean, I'm asking if it, well, let me ask you this, Mr. Davis, let me ask you this question. I'm sort of curious. It seems as though we're saying it's moot because basically you've done everything here. So what if we do enter the injunction and see likelihood of success, and we go on and says, okay, it's limited relief in terms of what you can do. You can't access it. Does that offend you? I mean, does that change anything?
It changes absolutely nothing, but it would be
let me make sure I hear what you're saying. You're saying you would not be harmed if we entered the injunction or entered this order in the limited way in which it's entered here, because that's what's already going on. So you really wouldn't be harmed.
It would be an extraordinary act by this court. It would be the equivalent of entering an order predicting.
I understand that, but I want to know,
February of 2021. That's what you've
Mr.
been doing,
Davis?
Judge Wynn.
Do you hear Judge Wynn talking?
I do.
Thank you. Then you should listen to me. I'm simply asking you a question that I think we both know the answer to, and that is you wouldn't be harmed by it. There may be some other reasons, but if they enter the order, it is fine. It's fine in terms of the status quo. It's going to be the same. Is that true?
No.
So you would be harmed.
I don't know what
So
the
what's
order
different?
In all honesty, Judge Wynn, I don't know what the order would say.
Well, let's say it says just that. It says there's a likelihood of success on the merit, and then balancing the equities here, you're not going to be able to access the data. Let's say it just says that. Does that harm you?
You would order the city police department not to access the data, so that when a criminal defendant moves to suppress 3 months from now, the city would be bound not to produce the relevant data to the criminal defendant? I don't understand.
But didn't you tell me those cases are all litigated separately, that's a motion to suppress, and then it would be a determination under the criminal law and Constitution that light for you to make that? I'm talking about for this case, because you're not in the criminal case. For this case, are you harmed? I mean, I know you want to handle criminal cases, everything else out there. I want to know, are you harmed here?
No, Judge Wynn, honestly, if these plaintiffs have standing to order the city's access to data in this case, then they have standing to intervene in a criminal case and move to suppress. This is what I'm confused.
Well, I'm not confused, but I want to make sure what you're saying is, I'm simply saying for this case. I'm not talking about what they can do in criminal cases. Okay. I'm asking, how are you harmed in this case? And if your harm is, well, it'll affect us, we want to deal with our criminal cases, then I'll accept that's what you're saying. But in this case, how are you harmed if you've already done this? If you've already voluntarily done these things and it's over, what's the harm in simply saying it to you?
Okay, again, what's the order say that we can't access the data?
Let's leave the question. Now let's let some others come on, because I think we're going to go round and round about this.
Yeah, because the order goes to, I think part of what Judge Wynn is asking about goes to the mootness question for me, which I'm having a challenge with. And so, as I understand it, the appellants asked for a preliminary injunction to enjoin the BPD from either collecting or accessing the data. And now they're no longer collecting. I got that. But as I thought I heard you say earlier, they are still accessing the data, albeit maybe 14% of it. So given that, and given that that's what the preliminary injunction requested, how is this moot then, if it's ongoing, the access?
See, this is the problem, Judge Thacker. What is the meaning of access? When the program was underway, the meaning of access meant the planes would fly when they could, depending on weather conditions and so on. And a crime would occur. The plane would come down, and whatever data the plane was able to capture that day goes into a server. And the detectives, the law enforcement officers on the ground, now know that there was a crime committed, one of the relevant crimes, a homicide or a carjacking, occurred at a certain location. So a request goes to the analyst to take a look at whatever you have at that location to see whether any of the pixels alert you to the possibility of perpetrators fleeing the scene or perhaps witnesses at the scene. That's what access has meant when the program was underway. Now, all the data except this 14% have been deleted. The servers are only storing the old data relevant to ongoing investigations. And so the access would be If John Doe gets indicted and his lawyer files a discovery motion in state court and the detective discovers that whether or not anything useful was developed as a result of the flyover, simply the fact that there was a request for an analysis would be relevant to, potentially relevant to a criminal defendant. That's what I meant when I answered the question, Judge Motz's question earlier about access. Of course, there's access to that data to provide to criminal defense attorneys, but there's no longer any access to conduct new investigations.
But Judge Davis, I'm sorry, Mr. Davis, I'm sorry. Mr. Davis, the problem is this. The whole problem with Carpenter is not that you have now distilled it to just criminal activity. I don't know if there's any Supreme Court case that ever said that you can broadly encompass surveillance of the general population so that you can later then distill it to a criminal activity and say that's fine because now that's the 14.2. The problem is in our country, in our brilliant Constitution, we don't allow drag nets because in 14th and 4th Amendment analysis, we always say, is your method of detection and enforcement so broad that an everyday citizen will be caught up in the net and you get information about them? That's the essence of the Carpenter issue, not whether now you've distilled this to a particular, yes, sure, you're glad to say, oh, I don't need any more. Maybe it was the 14% that you're after anyway. I don't know. I'm just hypothetically. But what about the other 86% of general population people who had their information access, their tracking? That's what Carpenter is talking about. I mean, everybody, just like the brilliance of the Kylo case about Justice Scalia, we're talking about thermography. Everybody had heat coming from their house. I said, well, that's just allowed. But the technology allows you to get that heat register and then go and get a warrant to find out whether or not they're growing marijuana. It was too broad, and the technology is way beyond this. I don't think most people feel that you walk out of the house, somebody, big brother, is tracking your every move, your every dot. And that's why I try to get my good colleagues and friends at the panel to understand it's not about a pixel. It's about individuals. And I still get to the point. This is about authority of this court to hear that question. Mootness is not something whether or not, well, I'd rather not hear it. Well, and I have no doubt, Judge, I keep saying Judge, that Mr. Davis, that you sincerely believe and that's your representation. That's no question. But that's a primrose that hopefully it might happen. But the world construes by its wit, but the court must construe by the law. And the law is if there's a violation under Carpenter, you don't get to decide whether or not you can take the residual, no matter whether you distill it to 14.2 or 0.2%. That's the question. And
the question
you have access to it. Wait a minute, Judge Niemeyer. And I haven't asked any questions today, I don't think. But the point is this, though. You now, I'm not arguing with you, but I'm saying the whole point, we're missing the whole point. The point is you surveil all Baltimoreans, wonderful people in a great city in America, all 600,000 of them. And now because you say I've now got it to what I want now, that question on the Carpenter is moot for whether or not preliminarily there's a likelihood they'll prevail. That is not moot. That question is not moot. Now, we might rule the way out, but the facts in this case, there is access, it's being used, and the question of whether or not it was illegally done, that's for this en banc court to decide, just like it was for the panel. You're right. That panel is gone. But now we stand here, and I never heard of justice being such that go someplace else to be heard under the Constitution. The place to do something is here, and the time to do it is now. I don't know what this court will decide, but it ought to decide that question and not kick it down the can and call it mootness, because it's not moot.
Just a minute. Can I just, Judge Davis, can I just have you consider in response to Judge Gregory's question, the notion that the plaintiffs were representatives of the general public, and the general public was seeking to enjoin a program that is now ended. The question is the only data that are retained, and we're not talking about access, you have access already. The only data we're talking about are the 14% reserved with respect to suspects. And all the other data is deleted and the program's ended. And for all general purposes, it looks like it's ended forever. But the question then comes to, why isn't it moot? Because only injunctive relief is being sought. Why isn't it moot as to the public who are not suspects? And it seems to me these plaintiffs only represent the public who are not suspects. There are no criminal suspects among the plaintiffs that we've heard about. And therefore, mootness clearly applies as to what's left. In other words, the 14% doesn't extend the case because there's no plaintiffs that represent those 14% of data. And so maybe you can include that standing notion in your response to Judge Gregory.
But be clear in your conclusion as to whether you're stating there is no public interest in that 14% data.
Well, what I can say is that I'm mindful of none other than Justice Scalia's concerns expressed in Kylo and other justices as well, that federal courts must be attuned to creeping technology and the impact that it has on our security and our privacy. I think we all get that. We all understand that. And the plaintiffs in this case appropriately brought a facial challenge to an innovative and controversial addition to the investigative techniques available to law enforcement.
Is there no public interest in the 14%, is what I'm asking. And trying to at least bend the question to understand Judge Niemeyer's point in conjunction with Judge Gregory. Is there no public interest in the 14%?
There has to be a public interest in the 14% because every criminal defendant that's caught up that has a possible relationship to this 100% of whatever the airplanes gathered are entitled to a fair trial. And under Brady versus Maryland, the Constitution entitles them to exculpatory evidence. So if this 14% contains anything that's possibly Brady material, not something that's going to help the prosecution, but something that's going to help a defendant, the Constitution protects that. And the court's going to get in a mess if it starts telling Baltimore to destroy evidence that's potentially helpful to somebody that's under indictment. We can't be doing that. If there's any Brady material in here that has to be preserved, then it has to be made available to the defendant.
Judge Wynn, I'm really trying to understand the concept in this context of the public interest.
Well, let me ask this way. Let me ask it this way. It is what you're saying is that it's only cars and individuals who are photographed in that 14% that are just criminal suspects. Is this part of a data of a larger scale? That's the question. In other words, is it specific showing this individual on just this car doing this, or is this data covering something more?
I don't know if this is responsive, Judge Wynn, but if the plane were to fly over on a Saturday, bright sunny day, and lo and behold, there are no crimes committed that day in Baltimore City. None of the relevant 4 crimes. No carjackings, no homicides, which is what Ms. Bridgeford works studiously on, cutting down the homicides. So if there is no one of the 4 index crimes on that Saturday when those planes fly over, that data, whoever's in the city, there's a pixel. There's a pixel for everyone in the city that day that the plane flies over. But no crime, all that data gets deleted. It's worthless.
Okay, but suppose there is a crime.
So if there's a crime, presumably a day or so later, when the detectives learn of the crime, obviously if it's a homicide, if it's a shooting, the officers show up at the scene, and the investigative approaches are engaged, and a request is made to the vendor to examine that area of the city where the crime occurred.
In other words, gain
imagine,
access to that data is what you're saying. A request is made to gain access to that data for the purpose of determining whether there's a crime. Is that what you're saying?
No, not whether there's a crime. We already know there's a crime.
But you're gaining access to all of the data. And in order to be able to find there's a crime, you got to look at everything that's there. Then you decide there's a crime.
No, if there's a shooting at Main and 12th, a day or so later, a request goes to the vendor. What do you have at Main and 12th between noon and 4 p.m.? Because there was a shooting, a non-fatal shooting of someone at that intersection at around 2 o'clock. They look at the pixels that have been captured from that day, and they try to determine whether there are any suspicious movements in those pixels that could rationally be tied to the crime. So obviously, if you see a vehicle speed away from 12th and Main, a second after there's been a shooting, your attention is going to be drawn to that pixel. And so the pixel goes at a rapid rate of speed east on Main Street. And lo and behold, there's a poll camera and maybe a license plate reader up at 14th and Main. So they take a look at whatever that camera, that poll camera can give them. And it turns out that the pixel was actually a red Nissan, and that license plate reader captures it speeding away from 14th and Main. Now we've got some data.
Okay, but what is preserved, Mr. Davis?
All of that is preserved.
But is it down to that 7th and Main or whatever it is,
yes.
Or is it a bigger?
It's
picture?
that.
Well, how can it be just that? Because I understand it when you and I walk downtown Baltimore, Judge Niemeyer too, they're taking, the sweep is around the whole city, right?
Well, over the next 45 days, they track the pixels. So they track the pixel of the red Nissan, and nothing else is worth anything. I'm not sure I'm answering your question, Judge Mott, but whatever happened up on Broad Street at 2 o'clock is of no consequence. If they can't
it's no consequence to the police, but what I'm trying to figure out is what has been retained. And I don't, because it's so minute, I can't understand how you could retain just one pixel.
No, not one. No, of course not one pixel.
Well, then that's what I'm missing. Everything around it was retained too.
So the pixels are tracked.
I understand
They are tracked.
Right.
So if a pixel, okay,
even if it's tracked, you can't just, there's material around the tracked pixel.
And
it is preserved, right?
Mr. Davis, I think that the dialogue with you and Judge Motz and Judge Wynn and Judge Gregory indicates that there are some real factual questions about how the program operates, about what is, how long the tracking is, what is done, et cetera, et cetera. You know, all augurs back not only on the question surrounding mootness, but on the question surrounding the merits of the program. We need further factual development, and I would suggest that the more important the case, the more important it is that we follow our own jurisdictional limitations and not proceed prematurely. And it is very troublesome, I think, if we are going to be writing essentially on sand, because we don't know how the program operates, and we don't know how the questions relating to data can be resolved. And you say, well, go ahead and charge in with an opinion and answer all the carpenter questions and answer this and answer that. And I think that part of our dignity as a court and part of our adherence to the rule of law would counsel, in a case of this importance, that we not proceed prematurely in a matter like this, that we should give the district court a chance to develop the record. And to be flying forward in the midst of all these uncertainties, I really think would be quite unhelpful, because what you're talking about here is a facial challenge, which is brought through this program. And even in the Fourth Amendment area, the Supreme Court has been very skeptical of facial challenges to programs like checkpoints for drunk driving and the rest. And there's a preference for as applied challenges as opposed to facial challenges. And when we have a facial challenge to a program which might impact the entire country, and whether raises a basic question of whether aerial surveillance, for example, is going to be a permissible technique in curbing such things as the recent outbreak of domestic violence and domestic terrorism. For us to entertain and to rule on a facial challenge to a programmatic response on the part of the Baltimore community, and to do so before a developed record is in our hand, and to preempt the district court from developing that record, and to reverse an abuse of discretion for denying a preliminary injunction, and to do that, to ignore our own jurisdictional limitations on behalf of a facial challenge and a reversal of abuse of discretion on a program of this magnitude, it honestly seems to me a matter of unseemly haste. And I just don't understand the need to charge ahead when no one is being prejudiced by allowing the normal processes of our court and settled propositions of jurisdictional law to proceed in their own due course. Mr. Davis, do you understand the concerns I have about how precipitous this is?
I do, Judge Wilkinson.
Judge Keenan has a question.
Okay, yeah, Judge Davis, I'd like, if you would, to back things up just a little bit to your red Nissan example. Let's just say that the crime occurs, but there are no cameras that capture the speeding red Nissan. So the police really are at a loss to determine who committed this crime. And the reason why I'm asking this is that Carpenter really focuses on the danger of the retrospective potential use of evidence. And it seems to me we'd have a potentially retrospective use issue here. If, let's say there's a snitch who later is in jail or is in trouble and says, oh, I've got some information. I know who committed that homicide. Then can the Baltimore police, after the snitch has identified the person as Mr. Jones, can they then go back and cull through the 14% of the evidence to determine if, in fact, Mr. Jones is one of the pixelated dots, even though they weren't able to capture the speeding car on the cameras?
Judge Keenan, I love the hypothetical. And though hypothetical, what you're projecting is almost certain to happen. There will almost certainly be individuals 2 months from now, 5 months from now, a year from now, who will say to some detective, I know who committed some homicide at X and Y Street. Or I know who did the carjacking during the pandemic in July of 2020. That data will not be accessible to the police department. If there's no suspect who's been developed, that data are gone.
What if it was a group of people that did it and the police department is onto one of them? This is what I've always been worried about. In other words, you see one and his buddy, his longtime buddy, the police department finally gets some information on. And could he be the blue dot that's always next to the red dot?
There are no blue and red dots, Judge Motz. I said a red Nissan because the red
I understand
Nissan
that. But I thought on the
was captured by the
pixelated thing, on the thing that the raw data,
Okay.
things were tiny.
So
People were tiny. No?
So your friendly amendment to Judge Keenan's hypothetical posits that there are more than one potential perps, and the detectives have developed information about one of them.
Right.
And that's going to be in that 14%. That's going to be there. So if there are additional potential perpetrators who come to light or who identify, there may well be information in that data that might be massaged, if you will, to develop it. But my point is, Judge Keenan, you're right. And what you're not right about is that this aerial surveillance is simply a tool in the toolbox. And even though I've said to you there are 42 ongoing prosecutions, I can't tell you, and I'm very mindful about being outside the record here. I mean, the court has drawn me in, and I'm happy to come in. But Judge Wilkinson is surely right that this case needs to go back to the district court, and it will go back to the district court no matter what this court does. No matter what this court does, this case is going back to the district court.
It's already in the district court, Mr. Davis. There's no stay in effect. The case is in the district court, and it's the fact that nobody litigated it in the district court. They treat this as a final order appeal, and it's not.
Well,
there's no, the filing of the notice of appeal didn't stay the proceedings in the district court.
Quite right, Judge.
The fact is the litigants have done nothing in the district court.
Well, the plaintiffs have done nothing in the district court, Judge King. And in fairness to my brother.
All right, the plaintiffs haven't. They haven't litigated the case. All they want to do is take the appeal, but it's an interlocutory appeal of a denial of an injunction.
And in fairness to my brother, again, remember, it's a pandemic. The courts were closing. Judge Bennett issued his order in mid to late April, just when federal courts like state courts all over Maryland and the country were shutting down. And in fairness to the plaintiffs, they had to make a choice. They had to make a choice. Judge King, you're absolutely right. The city and the police department, within the constraints of the pandemic orders, would have been happy to forego the appeal and to litigate this case in the district court in front of Judge Bennett along the lines, frankly, that Judge Diaz has mentioned and that I've mentioned. Under protective orders, they could have been involved, if they wanted to, in the development of the program. But they had to make a choice. and bless their hearts, they chose to come to this court rather than fight their battles in the district court. I hope I get a chance
Mr.
to say
Davis,
something about Parker.
Judge Harris has a question.
Yeah, I have a question. So I want to talk about going back to the district court. If we dismiss this appeal under Article 3 as moot, we say we don't have jurisdiction to consider this, the program is over, the only people with any interest now are suspects. How does that play out back in district court? You're not going to argue in district court that the case is moot, right? I mean, the district court, we're saying we don't have Article 3 authority to hear this case, but the district court does?
No, it's a live controversy. The plaintiff's claim includes, as we've heard, what you might call an accessibility claim. Okay?
But why isn't that a live claim in front of us? I don't understand. If that's the claim that will make it not moot in the district court, why doesn't it make it not moot in our court?
There has been no discovery. There have been no.
Case doesn't become moot because the absence of discovery deprives us of jurisdiction to hear the case?
I'm sorry, Judge.
I guess I don't understand. I thought you were going to say maybe there was a damages or action or something, but you're saying that the 14% accessibility claim will make this a live dispute in the district court, but not in our court?
No, I think there's a live dispute, even if all the data had been deleted. The plaintiffs are masters of their claim. They filed a motion for a preliminary injunction, which was denied. The standard of review, as you all know, we all know, is abuse of discretion. And this is where I come back to your salient question, Judge Wynn. You won't hurt the police commissioner if this court issues an order that it lacks jurisdiction to issue. But I suggest to you most humbly that it would be very unfair to Judge Bennett for this court to slap his hand and make a ruling that he abused his discretion by denying a preliminary injunction, particularly in a case where the issue over the appropriateness of a preliminary injunction is itself moot.
Mr. Davis, wait a minute. I have a little problem with that. And I hear that sometimes. This is not an ad hominem issue about a judge slapping a judge. No one's trying. Our duty here in the Court of Appeals is not to slap anyone's hand. It's to answer a question that is at hand. And what's at hand is whether or not the court was wrong in finding that it had not met the burden of a preliminary injunction for both the program and access. Oh, we're not slapping hands. We're looking at Carpenter. We're looking at the Constitution and the cases. And that's not a slap of a hand. My goodness, that's never the metric for me. It's never whether a good judge or a bad judge. That's why I don't even like people to even mention the name of the district court judge. That's of no moment. The question is, this is a court of appeals and is asked to opine on a constitutional question. And that question is simple. It has nothing to do. This case is not moot. My goodness. I mean, it just belies the whole point. Certainly have access to it.
I don't think anybody said it's moot.
No. Nobody said it's moot? No, I'm not talking about the case. I'm talking about the question of whether or not a preliminary injunction should be granted. That's the question. Listen, we could rule one way or the other. Let's say we grant it. The district court can, in terms of deciding the merits, rule differently. They're never bound by our determination on a preliminary injunction. Everybody knows that. That's clear. Somebody act like, oh my goodness, the sky's gonna fall down because we changed the district court's ruling on preliminary injunction. So what? That's our job. It's not to kick a can down the road because we don't want to hear it. The panel embraced this case because when they had a chance to do the winner factors, they came out the different way. But now that panel decision is gone. Now this court is here to answer the question. And I think it's just really unbelievable to now talk about what strategy the plaintiffs did. They came to this court as soon as they could, begged for expedited hearing. Begged for it. This court didn't go on hiatus. I understand district courts had a tough time. But we've been handling appeals, thank God, throughout the pandemic. And we didn't give them an expedited hearing. We came later on, months later. program almost over. Matter of fact, I think they were almost stopped flying by the time we heard it. Nobody ever talked about, I think they were stopped. Nobody in the panel talked about this is moot because it was comfortable to make those decisions then. Is it now uncomfortable because we're on bonk?
Yeah. Mr. Davis, I hate to keep asking, but about accessibility, I just want to make sure I'm clear in my mind that the BPD, what I've heard you say is, number one, that the BPD can access that 14% of the data, and number two, that it has reserved its right to continue to do so, to continue to access that 14% of the data. Is that correct?
Under the compulsion of the United States Constitution, BPD and the state's attorney for Baltimore City must produce that data to any criminal defendant who files a motion to suppress, and even apart from a motion to suppress, who makes appropriate requests under discovery. Yes.
So I guess then I have one more clarifying question. Are you saying then that that 14% is only comprised of criminal defendants in ongoing prosecutions?
That is my understanding, Judge Thacker, absolutely. And I would urge this court to send it back, because it's going back no matter what, to fully explore that and all the other factual questions which have simply never been subject to adjudicative process in this case.
Wait a minute, Mr. Davis. Let me get the 14.2% correct, because figures are very important. Now, the planes were in the air for 6 months?
6 months. And by the way, there were never three. There were never three planes.
What planes? Two. Okay, let's say two. So for 6 months, that's roughly 180 days. Two planes were flying 12 hours a day. So that's 180 times 24. All right, that's two planes.
Sometimes above the cloud cover, sometimes below.
Exactly. And that's about 600,000 potential pixels you could get. Now, are you talking about 14.2% of that arithmetic of 180 days times 24 times 600,000 potential pixels? Is that the 14.2%?
I'm sorry, Judge Gregory. I'm talking about the material that were requested by the detectives conducting investigations of criminal acts, the four index crimes.
What's I know a little bit about arithmetic. What's the basis for the 14.2%? What is the 100%? That's what I'm trying to get to the first of what the 100% is before I get to that. What's the 100%?
And I hope and I expect that there will be factual development of that question.
So you don't know.
The 100% is not everything they ever captured. That's not 100%.
I'm not arguing with them. I'm just asking what is.
Understand.
Give 14, because our colleagues seem to suggest that that's the holy grail, 14.2%. That's not whole much. That's not much of what? For example, if someone peered in somebody's surveillance, hypothetically, into their bedrooms, and they captured 100 pictures of people in intimacy with their spouse, and they only have 14% of it, we only kept 14% of it. Do you think there'll be no public interest in the other people who are surveilled, but they're not involved in a criminal action?
I think that person should be prosecuted to the full extent of the law.
No, I'm not talking about prosecution. No. The whole, I don't know why we're missing Carpenter. What drives Carpenter is the fact that you're using this broad surveillance of the public to get it down to a distilled amount. Now you think you're at a safe harbor because, oh, this is just criminal prosecution. But to do that, you had to disturb, get in people's space. That's the question under Carpenter, and that has to be a live question. There's no
Judge
question.
Gregory, can I have 30 seconds to say what I think about Carpenter?
About what? About what?
About Carpenter.
About
about the Carpenter case.
Absolutely, you can argue.
I bet you're pro.
I am, absolutely. But this case is about as far from Carpenter as you're ever going to get. Why do I say that?
All right.
Remember, in Carpenter, what you had was targeted investigative activity of individual as to whom there was probable cause to believe he had committed an offense. Just like our Graham case in the Fourth Circuit. The investigators went and got the historical cell site information because they already had the phone number and they already had the identity of the alleged perpetrator. And what the Supreme Court found problematic, first of all, there was no voluntary disclosure of the movements by virtue of simply having your cell phone, even if it was turned off, pinging off a particular cell tower. So this prolonged, I think it was 66 days in Carpenter or whatever it was, this prolonged surveillance, backward looking, including surveillance in homes and residences and doctors' offices, that's what drove Carpenter. And it was the procedural context of a motion to suppress evidence, notwithstanding the incredible public interest. None of us wants to be surveilled using our mobile phones, which have become a part of our body, as the Chief Justice wrote in the Riley case. So that's Carpenter. Here, as I said before, the plane is flying, waiting for a crime to be committed.
Well, Mr. Davis, excuse me though, doesn't that arguably make the nature of this dragnet worse? At least in Carpenter, they had focused in on somebody, and here you have hundreds of thousands of innocent people being captured and preserved for retrospective analysis.
But Judge Keenan, you can use dragnet, and yeah, that's a pretty powerful word, but this case is not the early DNA cases. Remember the cases from upstate New York and elsewhere, a sexual assault or similar offense occurs, perpetrator leaves behind some DNA, and some sheriff comes on the television and says, we're going to expect every black man in this county to show up at the sheriff's office no later than Friday at 5 o'clock so that we can take a DNA swab. That's not this case. And I appreciate the concern for the creeping technology, but Judge Bennett got it right. And by the way, as you all know, the Baltimore City Police Department is under the aggressive, hands-on management of Chief District Judge James K. Bredar, has been for 3 years. And I don't want to suggest for 1 second that Judge Bredar approved this program. I would never say such a thing. But at the same time, Judge Bredar, the Department of Justice lawyers who brought the case against Baltimore City and who attend every monthly meeting between Judge Bredar and the monitor and the police department, there is good reason to believe, as Judge Bennett concluded, that on a weighing of the equities, an analysis of the constitutional claims that were asserted, the plaintiffs were unlikely to succeed on the merits. That issue is no longer relevant to anything for which this court has jurisdiction, most respectfully.
Mr. Davis, can I go back to the question I asked a long time ago, perhaps in a place far, far away, about the protective order and what a protective order would look like? So you answered half of the concern, and that is the ability of the plaintiffs to be able to access the data to be sure that they are not somehow implicated or part of that database. So that's fine. Then you gave us a pretty, I think, accurate, I hope accurate description of what it means to access the data, but you didn't say anything in the protective order exemplar that you presented that would also encompass part of the order, because it seems to me that Judge Gregory is absolutely correct that this, that with respect to the 86% of whatever the 100% is, they obviously have a live claim, but those people no longer have a claim for prospective relief because you've deleted the data with respect to them. It's the issue of the 14% and the access to that 14% of the data. So are you telling the court that the city of Baltimore, the Baltimore Police Department would gladly enter into a protective order that would limit access to the data in the way that you have described it?
I can think of no reason it wouldn't, Judge Diaz. I can think of no such reason.
Fair enough. Thank you.
Mr. Davis, let me ask one thing. I think I come back to the point that this is a facial challenge, and although facial challenges to programs have been entertained by the Supreme Court, they're still very much disfavored, and particularly facial challenges which purport to strike down an entire program in all of its manifestations. And I think it is well to go back and look at all the things that Baltimore did, whether one agrees with the program or not, to try to make this program work. They enlisted the help of law schools, both to gauge public reaction to the program and to assess its civil liberties implications. And they tried to build support for the program with ministers and also with the Chamber of Commerce. And they went to the governor with this. So it was a real community effort to try to address a phenomenon that we haven't talked really about in this argument, but that is a tragic rise in crime in the good city of Baltimore. It pains me that hasn't come up because I think that's so much a part of this case. And the Supreme Court in the Jones case with, I think it was Justice Alito, who was joined by Justice Kagan and Breyer and Sotomayor, indicated that communities have to be given leeway to strike the balance between combating crime and not intruding and invading personal privacy, and that under our federal system, communities and cities like that in Baltimore have to be given this leeway. And my concern is that if we just slam down the gate on these programs by reversing a district judge for denying a preliminary injunction and say to the district judge, no, you've got to enjoin these programs the very first chance right out of the gate. We are leaving, I fear, good communities like Baltimore and fine cities like Baltimore. We're leaving them cities without hope. And they're going to say to themselves, and it would not be remiss, if they're going to say to themselves, the courts are going to not only strike down whatever we come up with to try to deal with this really tragic problem. The courts are not only going to strike it down, they're going to strike it down before we can even assemble something which is a full record and given a full chance to explain ourselves and why we adopted this. And I just worry about the implications for cities across the country, and not only that, but for other applications, which is whether aerial surveillance can be utilized, for example, in attempting to curb, for example, the recent unhappy rise in domestic extremism. And in knocking this down, it seems to me we come awfully close to saying aerial surveillance is out of bounds. Can't use it, no matter how pressing the problem is. Because this was a fairly mild program, and it was whittled down and down and down in all sorts of ways to meet legitimate civil liberties concerns. But I worry about leaving cities which undertake community-wide efforts to address the tragic loss of life and the tragic increase in crime that goes up and up and up. And it just seems to me, I apologize for the length of these comments, but it seems to me we're leaving them without options and without hope. And that the good young people who could so contribute to this country are now going to be required to grow up in a community where I think homicides are prevalent and where the tone is set by drug rings and gang leaders, where violence is such that education can't go forward in a normal way, and where violence is such that businesses that could provide jobs in these communities will not wish to locate there. And to tell you the truth, it breaks my heart because I just feel so privileged to have had the advantages that this country has given me, and I want the good young people in West Baltimore to have those same advantages. I want them to have at least a measure of the opportunity in life that I've enjoyed. And I just worry that we're going to have cities throwing up their hands and saying, there's nothing we can do. And that's so sad. And you don't need to comment on that, Mr. Davis. I've appreciated both your argument and the argument of the appellant here. But there's a broader lesson, and I hadn't heard the rising crime rate to be mentioned. I was going to hold my tongue. I hadn't heard the rising crime rate in Baltimore and the prevalence of violent criminal acts really mentioned during the whole of the argument. And when I hadn't heard it mentioned, I thought, well, somebody ought to say something. And I don't ask that that you need to comment, Mr. Davis, other than to say, I really appreciated your argument and that of your opponent, but there's a real human interest at the bottom of this. And now I've finished what I had to say and will always give counsel a last word.
I would like to hear your comments, Mr. Davis. I'd like to hear your comments regarding surveillance in low-income neighborhoods as opposed to high-income neighborhoods and in different parts where there's high crime. I'd like to hear your comments on that.
I really appreciate that invitation, Judge Wynn. And Judge Wilkinson, thank you for your heartfelt comments. Another 15-year-old here in the city, West Baltimore, as you say, died yesterday from wounds he suffered in the middle of last week. And so, yes, the crime, the violence is just profound. But what we must keep in mind, and I know you know this, Judge Wilkinson, and I know all of you know this, we must never allow, never permit, you must never permit, as a federal court, a majoritarian approach as a means of addressing criminal activity and violence to trample or denigrate the individual constitutional rights of everybody. And this case really does bring to mind the situation in Chicago some years ago. Some of you may remember this. Serious criminal activity in one of the high-rise, I think it was Robert Taylor homes in Chicago, or Cabrini Green. And the police department and the prosecutors in Chicago came up with this program and went around to all the residents of the high-rises and asked them to sign ex ante consents to the entry into their living units. And at least in one building, a large majority of the residents signed those consents, essentially opening that entire building of several hundred residents to invasion by law enforcement at the least concern about criminal activity. And the civil liberties community and the broader community was outraged by that, as they should have been. And so a balance is necessary. There's no question about it. We don't fault Ms. Bridgeford and Mr. James 1 second for challenging this program. It's their right, guaranteed to them. The mayor, as I mentioned, has opposed it all along. He's never said, to my knowledge, that it was unconstitutional. His approach to addressing crime in Baltimore is of a public health, root cause, interventionist, substance abuse treatment, addressing the root causes of poverty, which are all legitimate. Our new police commissioner, working with two bosses now, a mayor and Judge Berdar, under the consent decree, has dedicated his entire life, came up here from New Orleans to help address the incredible, intractable problem of violence, particularly gun violence in Baltimore City. So there are good arguments on both sides. Courts, I agree, Judge Wilkinson, should hesitate to shut down good faith efforts, however innovative, however creative, and let the process play out. And that's what's happened here. Judge Bennett exercised his discretion, reviewed carefully the record, the limited record that was before him, and recall that the program was supposed to start on April 1st. And by agreement of the parties, the planes didn't go up. Judge Bennett made it very clear that he wanted to have a full, not an evidentiary hearing, but full oral argument and briefing on the issue. And that's what happened. And he brought the best that he could bring to this analysis. And he applied the 4-factor test in all good faith. And he issued promptly a well-reasoned, thorough, 34-page memorandum opinion explaining his justification for denying the preliminary injunction. And as I said before, and Judge King, you're absolutely right, there's no reason whatsoever, apart from the pandemic constraints, that even with an appeal, even with an interlocutory appeal, the case could have and would have proceeded in the district court. It's not a defendant's burden, particularly a defendant who's prevailed on a motion for a preliminary injunction to push the litigation. But the commissioner and the police department would have been perfectly happy, prepared to do what I said they would do, Judge Diaz, to engage with counsel, to help counsel better understand the proceedings. The city, the police department, Commissioner Harrison has nothing to hide, absolutely nothing to hide. And people of good faith can disagree about which side of the constitutional line this program as it used to exist, because it doesn't exist anymore. And it's not coming back to Baltimore. So I appreciate Judge Wilkinson's comments. I appreciate all of the questions from the court. And I know that my brother on the other side appreciates the attention that you've given us. This has got to be the longest in-bank argument in the history of the Fourth Circuit. And that's a testament to the concern and respect that this court has brought to the claims that plaintiff is pressing here. So thank you all very much. Unless there are any further questions, I will stand down.
Thank you, Mr. Davis. Mr. Kaufman?
Thank you, Your Honor. And I know it's been a very long day for the court. So I just really have 5 quick points, truly in rebuttal to what my colleague was talking about. First, Judge Harris, as you mentioned, there was no answer from my friend about why, if it is not moot on remand, it's moot now. There was no answer because the request is the same. Pause access, below it will be pause access, and perhaps expunge data. But if it's not moot on remand, it's not moot now. Number 2, a lot of talk about the 14% of data that the BPD has. And just to clarify from what my friend said, that's not 14% only related to criminals. That's 14% of the total data that has been collected here. And I understand they've made an attempt to narrow down, but they're still getting data surrounding all of these tracks of not just criminals, witnesses, and explicitly in the contract, people that those individuals run into. And they will then see, oh, that person met that one at that corner. We're going to track that person now. So all of that data is there. And the plaintiffs have put in uncontested declarations that because of the nature of their work, where they go visit crime scenes shortly after homicides take place, that they are likely to be even within the smaller set of data. So I really think the 14% of data demonstrates very clearly that there is a live controversy now. Third, there was some...
Mr. Kaufman,
yes,
the city has, Judge Davis, Mr. Davis has articulated the willingness to enter into a protective order pending the trial of this, such that the data will be used in a very controlled basis. I mean, at this point, the data is collected and it's in the system. So it's not an access question anymore. It's a question of how it's being used. And I gather the city is saying that they're willing to enter into a protective order for those data so as to not have any misuse pending the trial. What's your view on that?
Well, Your Honor, I think this is very related to Judge Diaz's question too about a potential stipulation. And I guess I would just say it's the defendant's motion to dismiss this case as moot. It's their burden to establish that it is moot. They have never approached us with this kind of stipulation. And I think it's relevant that only in response to questioning from the en banc court has this idea even come up. And again,
well, let me ask you, I'm still asking you, I'm not asking you to accuse or criticize his offer. I'm asking you, what would be your position on such a thing? You'd be willing to negotiate a protective order?
Your Honor, I'm not here to represent that we would negotiate, of course, but I can't tell you what the terms of that would be, in part because the department continues to claim that this is entirely lawful. And so we do need this court to intervene on that point. And the way the court persuades a litigant to enter into an agreement to abide by some kind of rule is by entering an injunction. And that is what we're asking for here.
What you need to do is go back to the district court and litigate until you get a final order.
Well,
and,
Your Honor,
that could result from all sorts of agreements between the lawyers, and should. Lawyers sit down every day and agree on discovery procedures and stipulation to assist the resolution of cases. And you come up here with a final order. That's under 1291, we hear final appeals. That's our business. We don't hear interlocutory appeals regularly.
Well, Your Honor, I don't think there's really a question of the court's jurisdiction over this appeal. And I guess I would just say, again, that there is a pending motion to dismiss in the district court. So there is, I would be very surprised.
Well, if the pending motion to dismiss is granted, there will be a final order.
There will be a final order and presenting this court with the same exact question, Your Honor.
And Judge Niemeyer asked you a very logical question about whether you could come up with whether you'd be willing to agree to a protective order. And you said you don't want to want to do a dismissal. Maybe that could be part of it. That you need to sit down and do it. I mean, the case has been pending all this time. The case has been pending all this time, and nobody's done anything.
Your Honor, respectfully, I'll just repeat again. It's defendant's burden to show mootness. If they wanted to moot out the case or somehow neutralize the appeal by offering a stipulation, they haven't done so. I just want to finish.
No, but the case in the district court is pending. After you came up here, you didn't do anything with it. You just let it sit.
Your Honor, the department filed a motion to dismiss, and then the court entered an order pausing all the proceedings in the district court pending resolution by this court. And it just took all summer, and now it's taking into the spring. But I just respectfully, I don't think that the sort of envisioned proceeding on remand is what some of the court is suggesting. I really do just want to finish with the merits. I know I didn't get to talk very much about it. And you know, I just want to say to start, you know, listening to Judge Wilkinson, you know, I listened to a lot of his comments from the last argument. I listened to them here, and they're very heartfelt, and I completely understand the sentiment that Judge Wilkinson is putting forth. But I also just want to emphasize, and Judge Gregory talked a lot about this in his really eloquent dissent, but our plaintiffs are the perfect people to understand the severity of the problems in Baltimore. And so I really don't think that this challenge, and I heard my friend acknowledge this, that this challenge in any way pushes aside the concerns that Judge Wilkinson is putting out. Just on Carpenter, I just one more second here. You know, this is exactly the kind of too permeating police surveillance that Chief Justice Roberts warned about in that case. He said it was off the table, and the good intentions were there in that case as well to solve crimes. And so the Supreme Court has sought time and again to preserve the degree of privacy that existed at the drafting of the Fourth Amendment, when the Fourth Amendment was adopted. And I would submit to this court that the founders would be absolutely horrified by a program of mass surveillance from the sky that logged the movements of all Baltimoreans for 180 days. I just think that's completely incompatible with the Fourth Amendment, and it's incompatible with the Supreme Court's ruling in Carpenter. With that, I really want to thank the court very gratefully for the amount of time they allotted to the argument and their great questions and consideration. And if there are no further questions, I think we can call it a day.
Thank you, Mr. Kaufman, Mr. Davis. Thank you so much for your argument. Well done, both sides. And we can't come down and greet you, but know nonetheless that we are very appreciative and wish you well, be safe, and stay well. Thank you so much. I'm going to ask the clerk to adjourn, to at least, I guess, adjourn the court till tomorrow at 9:30.
I thank your honors.
Thank you, your honors.
Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
All right, Judge Gregory, I'm going to move everyone into the